Good morning, everyone. My name is Christopher Bilcock. I get the privilege of serving as presiding judge today. I'm joined by my colleagues, Judge Cameron, and our newest colleague, Judge Levency. And if you did not tune in yesterday, this is his first case call sitting. So now he's a veteran. And so yesterday I got to say some kind words about him. And today we get to roast him because I've been informed that it is your birthday today.
That is incorrect.
It's not today?
It was yesterday.
Oh, it was yesterday. Oh, so he's older and wiser in a lot of different forms. So
Someone violated the order to not disclose that to you.
yeah, happy belated birthday. It helps to know people. Is it your 50th?
No.
No, you're not as old as I am?
Close.
Yeah. I'm an old man, so I'm well over 50. So welcome to our second day of case call here in Detroit. I want to go over just a few preliminary comments for those of you who may be here for the first time at the Court of Appeals. I see some familiar faces here, so some of this will come as no surprise. First and foremost, we recognize that these cases are extremely important to both the litigants that are here, as well as the attorneys who have taken the time to brief and prepare for today. Often our decision here today is the final word on these cases. And so we realize how important it is on here. And I can assure you that we've been spending a lot of time, both with our clerks and amongst ourselves, reviewing the materials you've submitted, digging into the law and the facts, and have come here prepared to listen to what you have here to say. We have a very full schedule again today. And so I want to just go over a couple of rules. The first rule is everybody should know that there is an allotted time that all parties are allowed to have under the court rules. You're allotted that time. I'd encourage you, to think about how you use that time and also not feel like you have to use all that time if not necessary. Second, if there's more than one attorney for the appellant or the appellee, please let us know how you plan on dividing that time, if at all. If you're both planning to argue, if there's two parties, let us know at the front end so we can account for that accordingly. Third, appellant, let me know if you plan on reserving time for rebuttal, and I will help you and reserve some time for rebuttal. So let me know that on the front end. And the fourth and final rule is that these are public hearings and everything we say and do here today is being recorded. So if the matter involves juveniles, victims, things like that, please use initials only or some other identifier when speaking about the individual so that we can avoid any privacy concerns. We'll do our best every once in a while. Sometimes mistakes happen, but please do your best to avoid that. My last comment before we call the first case is my advice based on over 24 years of practice, both in my short time here on the bench. And again, it's where I sort of started. We are very, very familiar with the facts of your case. We're here today to hopefully engage in a conversation and fully understand the nuances and the nature of your arguments and focusing in on what you believe is dispositive to your case and help us understand any of the nuances that might not be clear from briefing. Please do not repeat what is in your briefs. We're very familiar with it. If there's a question we are asking, it's because it matters. Please do your best to answer that question directly, and it could very well be dispositive of your case. So with that, anything either of my colleagues like to share? All right, with that, we'll call our first matter today. It is docket item number 12, docket 376536, People v. Huston.
Good morning, Your Honors. May it please this honorable court, Alona Sharon, on behalf of the defendant appellant. I believe it's Mr. Houston, but
Houston?
that's fine.
Okay, yeah, thanks. I appreciate that.
I will not be reserving any time for rebuttal because I don't think there is much to rebut. Your Honor, Your Honors, this is a very straightforward appeal, probably the shortest brief I've ever written for this court. I do just want to take a moment to respond to a couple assertions made by the prosecution in its brief, and then if the court has any questions, I'd be happy to answer those. At page 6 of the prosecution's brief, the prosecution argues that there is nothing in the record to support defendant's claim that someone else caused the damages to the house or committed the theft of the items, and that it's defendant's burden to provide factual support for his position on appeal. I think this argument is really quite the red herring because, of course, the underlying argument to our brief is that there was insufficient evidence provided at the restitution hearing. And of course, the defendant bears no burden at a restitution hearing. The burden solely lies on the prosecution to produce evidence that the defendant is responsible for the losses incurred. Second, I just think it's clear. I don't contest that this damage was done, and I don't contest that Mr. Houston was located in the house. But the record is unambiguous that for 10 days, this house was unmonitored, and there are no witnesses and no evidence that Mr. Houston is responsible for the damage to the home. I think that's even more so when you look at the damage on the outside of the house, because no one reports ever seeing, there are no witnesses of Mr. Houston being seen outside of the house. Finally, the prosecution argues that the defendant did not produce any evidence that he wasn't responsible for the damage. And that, of course, is also not true because Mr. Houston took the stand. He was subjected to both direct and cross-examination, at which time he testified. I was in the house. He estimated between 9 to 12 hours. He testified that it was already in shambles when he arrived. Of course, we have no idea when the window was broken out. We have no idea if Mr. Houston was responsible for that or if he saw an opportunity. So given the complete lack of evidence, I do believe that this case very much mimics the Mackey case, which is cited in the brief. If I'm not mistaken, Judge Cameron, I believe you were on that panel, where, of course, in that case, it was also undisputed that the defendants drove around on this field. They were present. They had engaged in this act, but this.
The up north trucks going through fields.
Yes.
Yeah, I remember.
You remember that?
Sure,
I always
do.
wonder if your honors remember every case.
I don't remember cases. I remember the facts.
So, and in that case, Your Honor, your panel vacated the restitution, finding that the award of restitution was simply based on assumption and conjecture, I think was the exact phrase that the court used. I think this case is no different. I ask that the court remand the matter back to the trial court to vacate the restitution award and for an amended judgment of sentence.
Counsel, just two questions. One,
Yes.
as you said, was there any evidence that anyone else, there was evidence that your client was there for 9 to 10 hours, right?
Yes.
Was there any evidence that anyone else was there prior to the owner leaving the property prior to your client? Was there any evidence one way or the other?
No, Your Honor.
Okay,
I can't dispute that.
okay. And then why is this not, the trial court heard from your client and had that evidence? Why is that not a credibility determination? Isn't that for us, that's kind of a high hill to climb over, right?
Sure. So, okay, so that my client testifies that he didn't commit it. Even if you take that out, there's still no evidence that he did commit it, right? Which is what the prosecution has to provide. There has to be something other than mere presence, right?
I understand the point you're making. What's the case law or the precedent that says that mere presence isn't enough, that the circumstantial evidence of this case isn't enough?
Well, there has to be a causal connection between the crime and the harm that you're seeking the restitution for. And that's simply the factual basis of the plea did not set that forth, and neither does the discovery in the case, neither does the testimony from the restitution. The fact that he is there is not enough to connect him to the damage that is done to the house. There's just simply no evidence. I mean, when you look at
I guess help me understand why the trial court couldn't make credibility determinations and connect the dots. Owner leaves property, says property's fine. Your client's found in there after 9 to 10 hours, property's not fine.
10 days later.
10 days later, but no evidence introduced one way or the other that whether anybody else was in there, so the only evidence before the court is your client was indeed there for 9 to 10 hours. Damage found. Why is that not enough circumstantial evidence that it's a reasonable conclusion that to reach that?
Thank you, Your Honor. Two things. One is, I think, given the extent of the damage, a removal of an air conditioning unit, removal of pipes on the outside of the house, suggestion that Mr. Houston could have accomplished that in a 9 to 12-hour window and not a single person would have seen it, I think makes it highly suspect that he is responsible for all of that damage. And again, I just reiterate that it is on the prosecution to provide some type of concrete evidence that he is the one responsible.
So is your dispute with is it an all or nothing? Like, is it a dispute? Is your dispute with, do you concede that there was some damage caused by your client? And
No.
so so you're saying no damage?
I will not concede that because Mr.
Okay.
Houston's testimony is that the home was already in shambles when he entered the home. And I think also to go back to the Mackey case, right? In that case, this court actually had evidence and these gentlemen admitted to having driving on this field, right? They just disputed whether or not their driving on the field caused the damage or someone else driving on the field. And so I think it's the same thing, right? They were on the field. It's undisputed that a significant amount, I think over $100,000 of damage was committed on that field. But there wasn't enough to show that they actually caused it. And that's exactly what the issue is here, because you have 9.5 days that is unaccounted for.
Let
And
me,
yes,
let me play out your mere presence
Yes.
argument a little bit.
of course, Your Honor.
So this is a much stronger, what I'm going to present you is a stronger, and I'll acknowledge it, a stronger case for restitution. Okay.
Okay.
So you don't feel like you have to, in fact, don't distinguish it from your case. I'm wondering what your answer would be in this scenario.
Sure.
Back when they used to have car ignitions on the column of
Okay,
the steering wheel, back in those days,
okay.
it was common for people to break.
Before you were born, but when we were
Yeah.
born.
It was common
I don't
for.
know what that says about my age, but I'm sorry, Your Honor, go ahead.
It was common for thieves to break the ignition and shove like a screwdriver or something to get the car going and drive away. If someone was found operating, they're pulled over, routine traffic stop, and they're caught driving the car, a stolen car.
Mhm.
They can't prove he stole it, but he's driving the stolen car.
Sure.
And he pleads guilty to driving a stolen car. And and at sentencing, the trial court imposes restitution, an order of restitution for the damage done to the steering column.
Sure.
Which the defendant denies at the restitution hearing that I didn't damage the steering column. I was given it by someone else, right? I didn't steal the car. I'm just joyriding.
Sure.
So in that situation where all you have is presence and a denial, although the connection is, I think, closer, arguably, than what you have, would that be a proper order of restitution, ordering the defendant to pay for the damage done to the steering column of the car?
Only if the prosecution could prove that the driving of the vehicle caused some level of additional damage beyond the action that Your Honor described.
Right.
Of the insertion of whatever into the,
Right, screwdriver or some
Yes, thank
object.
you.
Yeah, right.
I think absent any proof that he caused some additional damage and they have no proof that he's the one who actually did that. And also, I think what's also important, now that I think about it, right, the crime he would be committing is receiving and concealing stolen property,
Mhm.
right?
Mhm.
There has to be a connection. Oh, what's McKinley, I think I want to say. There has to be a causal connection, right, between the crime that he's convicted of and then the matter that you're seeking the restitution. So there is no damage in connection to the receiving and concealing stolen property. It's the actual action of the screwdriver and the damage to the car. So I think that's actually even a stronger case that restitution would not be appropriate because of the nature of the offense that he would be pleading to under. I want to say it's McKinley, but you're challenging me right now.
Okay,
Off
all
the
right.
top of my head.
That's all right.
So, so
yes.
just to follow up in terms of the mere presence, is your best, I guess, your best case or precedent precedent for us to review is the Mackey case that you're referring to. Is there anything, is there another case out there that suggests, look, mere presence isn't enough? Or, and I'm not saying mere presence is all we have here, but to use the sort of the
Sure.
phrase we've been discussing.
I found it to be the most persuasive. You
Okay.
know, if I would have found other cases that I thought were similar or just as persuasive, I would have included them in the brief, but it's a very recent case that this court presided over. And I think the facts are very much on point to what we have here. We just have assumption and conjecture here without any proof, and that is insufficient to award the restitution.
Yeah, in that case, there were multiple vehicles involved, right? And it was undisputed over the course of several days. And the defendant in that case, Mackey, denied having did the damage in that particular area. I
Right,
think
I-
he denied driving in the area that was the source of most of the restitution.
Yes, and I don't know why I feel like this, but that that there were co-defendants in that case, but maybe I'm wrong. But either way, yes, you are correct.
Okay.
But again, that phrase conjecture and assumption, I think applies here as equally, Your Honors.
Understood. Thank you for helping flesh out some of that.
Thank you, Your
I
Honors.
appreciate it.
And welcome to both of you to the court, because I haven't had the opportunity to argue before either of you. So I'll see you at the 11 o'clock call.
See you in a bit. Thank you. That case is submitted. Moving to item number 13, docket number 373063, People v. Sterling. Council, please approach.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Sterling.
Good to see you in person this month.
Be here. What I'm about to say is a quote, and I want to make sure the court doesn't misinterpret my statement, but the words, quote, "You look like you could use a blowjob," close quote, just do not seem to me to be an accosting, an enticement, a solicitation, or an inducement. It seems more like actually an opinion. I don't really believe that there was sufficient evidence to convict my client of this offense based upon that comment. We believe that the evidence simply did not present itself, and this was exacerbated, I think, by the fact that the prior conviction came out. And while the prosecutor argues that Old Chief does not apply, it still would be inadmissible as propensity evidence. There was no notice given. There was no reason, I think, to bring out the fact that there was a prior. The suggestion is that, well, we need to show the prior to show the intent on the current offense. But
Let me ask you this. I guess I thought from the brief that you were suggesting that it shouldn't have, the prior judgment of conviction shouldn't have been admitted. Instead, there should have just been a stipulation that it exists. Am I understanding that right, or is that different? Am I wrong?
Well, under Old Chief, yeah, you're entitled to stipulate that there was a prior conviction without having to go into details about the nature of the conviction or any of the details.
But are you saying a stipulation would have been okay?
Well, the more I think about it, the fact is that there was no real basis for it to come in anyway because it's propensity evidence.
That's not what you argue in the brief, right?
Well, I think I did use the word propensity in the brief. So even if the major, I think, thrust of the argument was the Old Chief stipulation issue, it still is propensity evidence. And
Because I guess the judgment was redacted, right?
yes,
Okay, because my question ultimately wasn't going to be what would the stipulation had said different from the judgment? You know, what information would have, from the judgment that was admitted would not have been included in the stipulation, right? They already redacted some of the information that was
Well,
deemed more prejudicial.
they did not
So-
redact, I think, the fact that it was a similar offense.
Like you said, that was at least purportedly to prove intent, right?
Allegedly, yeah, but
Okay.
it also is propensity evidence, and for that reason, I don't think it should have been admissible at all, with or without a stipulation.
But again, I guess I didn't see that argument in the brief. I thought the argument in your brief was more, they should have resolved the issue through a stipulation.
It was, but reviewing, and this is on page 10, the all that was relevant for purposes of this prosecution was that appellant accosted a child for immoral purposes. And then it says, although this person added propensity evidence that he too was accosted 7 years earlier. So, yeah, I do argue that it is a propensity evidence, albeit not as the major thrust of the argument. but it-
Propensity evidence isn't per se improper.
Well, no, propensity evidence is allowed under specific instances under 769, I think, what is it, 11 or something like that, A and B,
27.
domestic violence situations, other situations involving children, but it requires notice. And there was no notice given.
Unless it's given, okay. I understand. So I guess my question is, what would the stipulation have said different? You can't identify anything different. You're just saying that a stipulation wouldn't have been an alternative.
Well, there could have been a stipulation which would have eliminated the necessity for actual testimony. But I think that even by stipulation, it should not have come in because of the propensity involved. And like I said, it is not prominent in the argument, but it is mentioned. And
Thank you.
Thank you.
Just let me check and see if anybody's got any questions before you take off on us.
No, I don't.
Any further questions?
That was my only.
All right, thanks. And we had a notice that Mr. Morton wanted to appear for remote argument.
And
Is that,
then when the assignments came out, they were just having me cover as my office.
you're all good? Okay, I just wanted to make sure we weren't missing anybody on our end.
No, I am standing in for Mr. Morton. today.
Okay, great. Welcome, good to see you.
Good morning, Your Honor. It's Monica Wilson, Assistant Attorney General on behalf of the people. I would just make a couple of points. I know Mr. Morton covered this in his brief pretty well. For these purposes, propensity is a proper purpose, that the 27A and 27B evidence was admitted without objection. As to the stipulation, Old Chief is focused on the predicate, the felon in possession charge. And so in this case, and if you look at Old Chief in the cases cited in the brief, if the only reason is to show the prior felony for felon in possession convictions, then yes, if there's a stipulation offered, they have to take it. In this case, I don't believe a stipulation was offered, but more importantly, this has to do with more than just the fact that there is a prior conviction. It goes to the heart of the issue, because when the defendant leaned over and said this to a child at a gas station to the effect of, and again, pardon my language, you look like you need a blowjob, you also have to look at, and the question is whether or not that was an intent to induce this minor into sexual activity. You also have to just look at not just the words, but the attendant circumstances where he leaned over and said this so that no one else could hear. It was kind of a lean over and whisper. So it wasn't more of just an opinion. I think a reasonable jury could find that was essentially an offer to, how do I say this? A sexual act on a child, where he was offering to perform that act on the child. And again, so I think for the sufficiency purposes, a reasonable jury could find that that's what he meant when he said that. And the evidence from the prior conviction, as well as the other acts evidence, can also, one, its propensity is a proper purpose under that statute. But two, I think it explains that, considering that he had sexually abused a child in the past in the same fashion, then it could go to his intent of what he meant when he said that.
How do you deal with the no notice issue?
There was no objection lodged to it, so, and I think that if the notice had been provided, it would have clearly been allowed. So, and I don't think he raises an ineffective claim, if I remember correctly, that trial counsel was ineffective for not objecting to it. And I think that, and I apologize, I believe the case law is that even without the notice, I think they knew this was coming in, so it wasn't any unfair surprise in that had the notice been provided, it would have been admissible. But I don't believe an ineffective claim was lodged for failing to object to it.
Nothing further. Okay,
Thank you.
you have time for rebuttal? Why don't you start with the addressing Judge Cameron's question is, yeah,
I don't think that it can be addressed under, I guess, what I think maybe counsel suggesting would be like harmless error. The notice requirement is in the statute, and they say, well, they knew about it, and so we don't have to give him a notice of something he already knows of. There's no such provision in the law. The law clearly requires that notice be given. In fact, there are really specifics about when notice must be given, and specifically going back to the distance in time. And here, 7 years earlier, so there's also there could have been an argument that perhaps the probative value is substantially outweighed by the prejudicial effect. There are a lot of parameters which were not explored because of the fact that it just popped up at trial. And it did really not give anybody an opportunity to suggest why it should not have come in. And I think the probative value was minimal given the age. The prejudicial effect was substantial given the similarities. And the fact is that it is propensity evidence, which was not noticed. There's one other comment I would like to make, and that is,
Question. I'm sorry, I'm trying to skim through the brief here. I mean, your brief doesn't contest the lack of notice for this evidence, right? It focuses on the should have had a stipulation.
yeah, but it does
So
mention.
do we know for
propensity.
sure that there was no notice? I mean, because I don't think it was raised by either party. Am I missing something? Like, I don't think, neither side, because it wasn't raised by the appellant. It wasn't an issue. So I understand that the state has sort of, you know, especially since you were trial counsel, as I understand it. So I guess I'd like to double check that before were you trial counsel, sir? I'm sorry.
Was I trying to what?
Were you trial counsel?
No, Your Honor.
Okay, I didn't think so. Okay, I just don't know for sure then. I would need to double check to see whether notice, because it just wasn't raised in the briefs that I saw, but I could be mistaken.
The one other comment I would like to make is that after the comment allegedly made by my client, quote unquote, "You look like you could use a blowjob," the complainant says, "I don't know what that means." Okay, and he says at trial, "Well, I really did know what it means," but that's beside the point. The fact is that my client allegedly responded, "Get out of here." He's not there to say, "Well, let me explain, let me show you, let me give you an example." He's saying, "Go." So, I mean, that's more evidence that there's no intent by this comment just to, in fact, entice or lure or accost or solicit or any of the other adjectives which are maybe present in that statute.
any other questions?
All set.
All right, thank you, Mr. Simon.
Thank
That case is submitted. Moving on to item number 14, docket number 373-611. People v. Sexton. Ms. Wilson. Mr. Simon. Good to see you again. It's been too long.
Jonathan Simon, on behalf of Mr. Sexton, may it please the court, good morning. I know that the court is familiar with the arguments on both sides. I would submit, and I think the law is clear that criminal law is considers contract law in determining offers and acceptances. And it does seem to me that the waiver of the preliminary examination based upon the email from the prosecutor, and this is the chief assistant prosecutor who says, this is what, if you waive the exam, we're looking at dismissing count one and a sentence within the 50 to 100-month guideline range. And the response from counsel is, yeah, I'm going to waive the exam. And so we see that as detrimental reliance. And so there is, I think, created a contract. I think under contract law, first year law school, what is that? A unilateral contract. And so there should have been that offer. I think after counsel relied upon it by waiving the examination, the chief prosecutor, the elected official says, no, we can't do that. We're not doing that. He didn't have authority to do that. His chief assistant, he's saying, did not have the authority to make that offer. And so it does proceed at trial. And at trial, the prosecutor asked him, well, didn't you have a prior? And This was already something that had been suppressed.
That's actually not what he asked.
Well, no, it wasn't a quote. The quote is in the.
Well, I think that's important because I think frankly, the government also makes a mistake in conceding that they asked him about a prior conviction. But if you look at the transcript, that's not what was asked. Is that the first time you ever got behind the wheel after drinking?
Yeah, and he says, no, sir. How many times do you estimate you did that? And the
That
response
isn't-
is, it's the second time.
I mean,
And the
I
prosecutor
would
says,
venture to guess most of the people in this room have gotten behind the wheel after having a drink, right? Like that doesn't imply a conviction. That doesn't even imply criminal activity, does it?
well, it was something that the prosecutor knew or should have known not to engage in because this was already
That's not my
been.
question.
No, it doesn't suggest, actually, it doesn't ask about a prior conviction.
It doesn't even ask about criminal activity. It's not necessarily criminal to get behind the wheel after drinking if you're not above the legal limit, right? I mean,
Well, yeah, 0.08 is the legal limit where there's a presumption of intoxication. I suppose that there could be intoxication even below that, depending upon the, maybe the activities behind the wheel or the field sobriety test later. But no, it doesn't ask about a prior conviction, but it goes into an area which had already been, I think, thoroughly discussed, and it was to not be something which was to be raised at trial. In fact, it wasn't even defense counsel who stopped the proceedings before defense could even make an objection, I assume. But the court immediately called a sidebar.
let me ask you this though. Mr. Sexton didn't deny. In fact, he testified that he had been drinking before driving that night, right?
I believe so.
So this wasn't even propensity evidence to prove that he was drinking and driving that night, because that actually wasn't his defense or even a disputed issue, was it?
No, I don't think there was any dispute whether there had been consumption of alcohol. The question was whether there was intoxication.
I think the question was whether, I think it was whether he intended. Well, okay.
But the court immediately calls a sidebar and then they move on from there. And there's nothing said about it. There's no curative instruction. There's no request or for one. There's nothing said about it. It's just move on to the next question. And it seems to me that.
What about the questions that led up to that? I mean, there was no objection and you don't take issue on appeal with a question. You didn't have your license on that day. Prior to that day and leading up to it, you had driven without your license. He was also charged with driving without a license, right?
Yes.
So would that question have been improper?
Well, that wasn't something that came up at the pretrial hearing, so it's
That
something.
doesn't matter. That's even worse, right? Because then there was definitely no notice for the defense that those questions were going to be asked.
Well, I don't know that anybody was terribly concerned about a misdemeanor driving offense. The focus was.
Well, but
on
they were felony
charges.
driving offenses
Yes.
because it was driving without a license causing death. It wasn't just driving without a license.
Well, yeah, that's correct. But do you have a license? No. Okay, but that pertains to the current offense. That didn't ask about prior offenses. It didn't ask, have you driven before without a license? Do you know that you didn't have a license? Do you know that you shouldn't be driving without a license? I don't really take issue with that line of questioning. Because he presents himself on the stand, and then the prosecutor, I think, has a right to go into those issues. But as far as prior offenses go, I think that was clearly out of bounds, and it should not have been an issue. And I think it rises to the level of misconduct, which I think should cause not only to have the conviction set aside, but also that it be done so with prejudice.
Mr. Simon, if I could go back to the plea offer issue for a moment. You said that there was, a detrimental reliance. I don't recall that being the thrust of the argument, but rather that the offer that somehow there was an offer and acceptance, right? Contractual provisions. But the email says, well, we'll do the plea just to keep the offer open. That seems to me an understanding that the plea deal or a bind over decision waiving the prelim wasn't contingent, wasn't wasn't done in reliance on this offer being accepted. As a matter of fact, the subsequent acts of defendant kind of reinforced that by requesting a Cobb's agreement, by going through wanting a Killebrew. All of those things seem to be evidence of, if not flat out rejection of the initial plea offer, certainly a counter offer. Isn't that what the record indicates? And if my understanding or reading that is wrong, tell me why.
Well, I don't recall the chronology, but I think that perhaps at that point, it was already made clear that that this was not going to be what the had been perhaps dangled out initially after the elected official says, no, my chief assistant had no authority to make that offer. I may be wrong about the chronology, but I do believe that saying we're going to, to leave this open by waiving the examination clearly should mean that that offer is still available once it gets to circuit court. So even though perhaps there was some attempts to sweeten the pot, I think that flat out recanting the offer, I think after the waiver of the examination, I think was done after there had been, like I said, detrimental reliance. And so we believe that the court should allow the case to be remanded for specific performance of that agreement. I'd like to, if I may, move on to argument 3, which was the sentencing. There was a departure. The sentence was 120 to 180 months, which was above the 120 exceeded the 50 to 100 month minimum sentence guideline range, which coincidentally was the same offer that had been made by the prosecutor. They had indicated that without the dismissal of count 1, there would have been a higher guideline range, but it turned out that the guideline range was 50 to 100 months. The court imposed a 120-month minimum, and we don't believe that there was sufficient reason for a departure or an explanation for the extent of the departure. At a minimum, Your Honors, we believe that Mr. Sexton should at least be allowed a resentencing.
Anything further? Nothing further? Ms. Wilson?
Good morning again, Your Honors. Monica Wilson, Assistant Attorney General. On behalf of the people, I am standing in today for my colleague, Ms. Davis. Your Honor, as it relates to the plea agreement, Judge Jabilcock, your questions were essentially what I was prepared to argue, that the email saying we're going to waive at a minimum to keep the written offer intact, I think that was the consideration for waiving the exam, was to allow him to continue negotiating, not that there was any manifested intent. Because once they got to circuit court, he didn't say to the court, hey, we need to set this for a plea hearing. Instead, he sought a Cobb's, then that didn't work, so he sought a Killebrew. So all of those things are consistent with, we're still trying to negotiate this, not that there was an accepted plea deal. He only then sought to enforce the specific plea deal once it was revoked. So, and the prosecution is allowed to revoke it anytime until it's accepted. And they tried a number of times to, essentially he was trying to get a better deal or some kind of sentence cap. And when that didn't happen, then, they're not required, the prosecutor to leave this offer open. But what we have here in terms of the specific performance of the plea deal, he never accepted it. And his actions at the circuit court level were consistent with, we do not have an accepted offer. His actions were consistent with, we're trying to figure out a better deal. And if it doesn't work, great. But the risk of that is, if you're continually trying to negotiate, that offer may get pulled, which is what happened in this case. So as it relates to count 3 or issue 3, my apologies, I believe the trial court gave some pretty detailed findings as to why the 20-month departure was appropriate. Talked about these on a C grade, the maximum OV points is 75. This gentleman was almost double that. His OV score alone was, I believe, 130 or 135, if I remember correctly. So that the extent of the OVs was not fully accounted for in the guidelines. And the trial court also gave pretty lengthy explanation of the effect that the mother's death and the father's pretty severe head injury had on the families, but as well as there was a 3-month-old child in the car with them that did survive. And unfortunately, her mother passed away. And because of his head injury, which I assume is a TBI, he really has no relationship with his daughter. So I believe when the trial court talked about, I believe it's OV5, about the effect on the family, it's an all or nothing. It's a 0 or a 15. And I think the trial court made some pretty specific findings as to why that was not fully accounted for. That not just the family of the family of the decedent, but also just this 3-year-old who, essentially lost both parents on that day. And so I think the trial court's findings were not an abuse of discretion. So other than that, I would rely upon Ms. Davis's brief unless your honors had any questions.
Questions?
Thank you.
Mr. Simon, do you have time for rebuttal? Nothing further?
Right.
Thank you. That matter will be submitted. Moving to item number 15, docket number 371415, Goldsmith v. Faith, Hope, and Love Outreach Center. Council, you may approach.
Hi, Your Honor. Good morning to the honorable panel. I just wanted to put my appearance on the record. As you all know, the appellant did not preserve oral argument. So Jehan Crump Gibson on behalf of the appellants.
Thank you. Mr. Weingarten?
Good morning, may it please the court. Harvey Weingarten appearing on behalf of the plaintiffs, appellees, Goldsmith and Therapeutics. I'm going to generally rely on the brief and present myself to answer your questions, but I do want to say quickly, I think that the statute involved is clear and unambiguous. The issue of intent to defraud is not an element of Section 1B, and that was the section which the court granted summary disposition on. However, even if it were an element, I think that the Perry and the Miller cases cited, I think by both of us, clearly say that when you misuse identifying information, that alone establishes the requisite intent to defraud. I do want to spend a moment on how we got to the special master. And then it was all by stipulation. The court did not impose any special master on us. We stipulated to having one. The trial court did not impose Chief Justice Young as the special master. We stipulated to Chief Justice Young. The damages hearing was well briefed. Each party had the chance to present any witness it wanted. Each party had the chance to and did present voluminous exhibits.
Counsel, am I correct that appellant neither here nor below argued that her behavior or her conduct in submitting the application with her business partner or without the business partner's contact information, that qualified under MCL 445.65 sub 2D as an affirmative defense, that she operated with consent? That was never argued below or in the briefs.
You are correct.
Is that correct?
Yes, sir.
Okay. Thank you.
The credibility was certainly an issue at the damages hearing, as Chief Justice Young said in his recommendation. The credibility of the witness's testimony supports both the court's liability determination and my damages recommendation. And most importantly, it was just that. It was a damages recommendation. It then was the court did not substitute Chief Justice Young as the trier in the case. It accepted the recommendation. The 8-page opinion accepting the order shows that the trial court did give it due consideration and didn't just rubber stamp it. I think for these reasons and reliance on the remainder of the brief, I think that's all I have to stress to this panel, and I'm prepared for your questions, if any.
Any questions? Judge Levency, any questions?
No.
Thank you.
That matter will be submitted. Thank you. Moving to item number 16, docket number 371470, In re conservatorship of IL. Counsel, please approach. They aren't marked as consolidated though. Yeah. And my colleague was just pointing out there are three related docket numbers. i- With deferring to my more senior colleague, I think it just for efficiency's purposes, to the extent that you need, what I'd like to avoid is repetition of facts and argument, and primarily the facts. I know the arguments are different across the three appeals. We're very familiar with them. So I just counsel client, we'll have enough time on all of them. We'll call them separate because they are separate matters. To the extent that we cannot repeat facts, that'd be appreciated.
Good morning.
Good morning.
May it please the court, Paul Letizier, appellate appearing pro per. I'd like to reserve 2 minutes for rebuttal.
So noted.
Thank you.
And just, oh no, never mind. Go ahead.
So for me, it comes down to four main keys. Arbitration, the parties bargained for it. The trial court applied the same clause twice in the case, then refused the third time. Records, the trial court found no production until May of 2023. The records shows 400 plus pages were served in September of 2022. Fees, on reconsideration, the court itself found the record was insufficient to set a reasonable fee. And the fourth item was conflict of interest. 3 independent procedural bars that finding. So I'd like to start with arbitration, because if the court agrees with us on that issue, the proceeding goes back to where the parties agreed it would go. Arbitration. The parties bargained for arbitration. They wrote it into item 16 of the approved settlement agreement. They named arbitrator Robert Iskrig Jr. for everything going forward. In item 16 of the agreement, any controversy or challenge to the enforcement of the agreement goes to Robert Iskrig Jr. The language is broad and it is mandatory. The trial court already applied this clause twice, February 2022, where the petition for instructions sent back to Robert Iskrig. Again, August 2022, petition for reasonable communication sent back to Robert Iskrig. The third time, the court kept the case. I had also submitted a emergency motion to send the case prior to that to arbitration, which was denied. Hate's petition is on its face a challenge to the enforcement. Her own pleading alleges I disregarded the arbitrator's order. That is precisely what item 16 references. Everything goes back to Robert Iskrig. There is even record on during the trial on November 20, 2023, the trial court stated, really, this case should have gone back to the arbitrator who was familiar with these findings from day one. We're on our third judge. The arbitrator, Robert Iskrig, is the one that's been a constant person throughout this. My next is the record. Clear errors and abuse of discretion. September 22nd, 2022, I served the first accounting with sent a CD to all 4 parties, 400 plus pages, showed every penny in, every penny out for the account. Did the same process for the second accounting and the third accounting. The court found that nothing was produced until the May 24th, 2023. That finding is contradicted on the face of the record. September 29th, 2022, opposing counsel wrote back that acknowledged receipt of the CD in writing in my appendix W that's noted. So there is, again, substantiated claim that they received the 400+ pages of documents. Prior to September 22nd, 2022, an arbitration subpoena authorized by Mr. Iskrig also produced the bulk of the first accounting period's records that was provided to all parties. So Mrs. Bugren's request after that, 9 months later, for copies of checks was a request for documents she had already had for 9 months earlier. Again, the records. MCR 5.310 subset C, sub 2, sub D requires records be reasonably available for examination. Further, that MCL 700 5417 subset 2 requires the conservator to exhibit these records on request of an interested party. Neither requires delivery on demand, but the trial court in the January 17th, 2024 order held that I breached my duty by not tendering documents without litigation. That is a standard the rule does not impose.
I think we understand sort of the underlying things. I think where this appeal really hinges on is the plain language of the arbitration agreement and what was or was not subject to arbitration. And so the settlement agreement, right?
Right.
That the language of the settlement agreement is really what the key is on appeal. I understand there's a bunch of issues about whether what you produced or not produced and all those kinds of things. There's lots of, everybody's got a take on that, right?
Yes.
I've have some personal experience with these things. And so focusing on, for us, why you think the plain language of the arbitration clause in the agreement covers the dispute and that it's supposed to go to arbitration.
Okay, so I can answer to that. So in the settlement agreement, it was any controversy or challenges to the enforcement of this agreement shall be interpreted, decided, and cost assessed by Robert Iskrig. The stress is any. Any and all. He kept it clean. If there was challenges, I filed a petition for a protective order on sharing financial data. That was served by the court and filed by the court. That would be outside of the settlement agreement. The settlement agreement, it was a challenge. This case should have gone back to the arbitrator because it was a challenge to a controversy or a challenge to the enforcement of the agreement.
Okay. Help us understand why the reading isn't, if there was a challenge to your appointment as opposed to your actions as the once appointed. Do you get the
I think-
distinction I'm making? That the agreement on its face, one read would be is that it's subject to arbitration, your appointment, that you are the person
Okay.
sitting in the seat, as opposed to your actions once in the seat.
If I'm understanding correctly, so at the point of the agreement, all 5 parties had counsel.
Mhm.
All parties agreed to the agreement.
Right.
There was no appeal to that. There was no challenge to that. They all, without constraints, agreed to the terms of the agreement.
But the agreement, the whole point of the settlement agreement was that it was your appointment as conservator, right?
It was
That
as
you'd
part
be-
of the settlement agreement was honoring in the ward's instructions, she had named who she wanted as conservator and she had named who she had wanted as her guardian.
Right. So the agreement and the settlement agreement dealt with, let's resolve the dispute over who is going to sit in the seat. Is that,
It was who would sit in the seat and issues going forward. Because then at the point,
how do you get, that's exactly the point. How do you get to the issues going forward under the plain language of the agreement?
well, if the agreement didn't handle the issues going forward, then at the point that we signed the agreement, it'd be null for anything forward. Then that agreement's.
Why,
done and
can't you can have an agreement that settles just the issue of who's sitting in the seat. Would you agree with that? You could have an agreement that just is,
who sits
let's
in-
all agree who's sitting in the seat.
Correct.
And we're gonna sign off on that and we all agree this is who's sitting in the seat. And reserve then challenges to how that person acts going forward through the normal course in front of the courts.
Right.
Why is that not the reasonable interpretation of this settlement agreement?
For me, as I read the agreement, it was just, it's all encompassing going today. And at the point that the ward was involved with, and her counsel with accepting the agreement, and me and my counsel and everybody else, the acceptance was today and going forward. It wasn't just, she agreed to having a conservator, having a guardian
Understood.
appointed.
Okay, well, maybe this would be a good time to hear from opposing counsel. I don't want to cut you off if you've got other things you want to add and
I mean-
let us hear.
For me, it's more just what you guys, your honors are well.
And one of my
versed in.
colleagues would
No,
hammer you for saying you
I know,
guys.
I got hammered earlier and I will get it again.
See?
Let me ask you this may, you can defer answering this question, but like if we agree with you on the arbitration, I mean, there's a lot's happened since then.
Correct.
So what happens? I mean,
So for me, what the relief I'm looking for in all this is, for these reasons of everything, is I asked the court to vacate the January 17th, 2024 order and the June 6th, 2024 orders. Remand instructions to refer Mrs. Haight's petition to the arbitrator under item number 16. Keep the current conservator in place and have the case go where we all agreed for it to be on day one.
okay, but then, are you the conservative now?
No,
Okay, because, and again, I'm getting ahead of this, like, the next case is the appointment of Mr. Frazier as conservator.
correct.
That happened, and then Mr. Frazier was removed as conservator. So what you're saying, if we grant the relief requested, the other, at the very least, the next case is sort of moot, right? Or, I mean, it's something.
Correct. It's something. It could be mute. Because, I mean, my case,
I
you
understand.
know,
Okay,
and then there's another cross appeal and another appeal after that. No, I understand there's lots. But as Your Honor mentioned, I'm focusing solely on, again, the beginning and then back to the beginning where we started with,
I
settlement
understand,
agreement.
I understand.
Thank
Anything else?
you.
You have some time for rebuttal.
Yeah, I'll hold it. Thank you.
Yeah, I think we understood, we read the briefs, we understand the facts and understand the argument. I think, and we talked about, I think one of the key issues is arbitration, present versus appointment. So let's hear from the opposing counsel and then you'll have your time to rebut.
Excuse me.
And I will just note that appellee is limited to 10 minutes of oral argument.
Yes, Your Honor. Good morning. I'm Ed Nahat from the Kemp Klein Law Firm on behalf of appellee Michelle Haight, Mr. Letizier's sister, front row, her sister, unrepresented appellee Renee Bugren is sitting next to her on behalf of her mother, Yola Letitia. Renee Buchran is now Yola Letitia's legal guardian. Let me just address your initial question relative to the argument of arbitration. The arbitration agreement, Exhibit H in my brief, covers more than just appointments of conservatorship and guardianship at that time. There are other clauses in that agreement, specifically that Mr. Letitia and his friend, John Cooper, an attorney, would provide a promissory note because it hadn't been provided to my client at that time. It had only been disclosed that there was one.
So that'd be another dispute that if
Right,
something
and it
came up to
became a
that, that'd be
dispute
subject to
later.
arbitration.
And it became a dispute and it went to arbitration under this agreement. That's why it went to arbitration, because the judge ordered it to arbitration. I filed it with the court, but the court ordered it to arbitration because here it is in this agreement. It also says that all 4 children will remain beneficiaries on all accounts, and we didn't have proof of it. And we filed a petition and that was ordered to arbitration in 2022. It also says that Paul Letitia may make gifts, and that issue was ordered to arbitration. So my
What?
point is that,
Go ahead.
pardon me, Your Honor.
Yep,
My
no, go
point
right
is
ahead.
that paragraph 16, the one that Mr. Letitia is so fond of, says any controversy or challenge to the enforcement of this agreement goes to the arbitrator. And so any controversy relative to the enforcement of it did go to the arbitrator. The enforcement of it, which was his appointment, not his removal.
Why is appointment, isn't removal just a flip side of appointment? And why is the conduct not just part and parcel with appointment?
Because
Let me take it out. Let me
All right.
let me take a step back, right? Because arbitration is just an alternative forum to court. And if you were in court, you wanted to challenge the appointment or anything related to that appointment, you'd go to court. So if you settled via arbitration the appointment, why is it not part and parcel of the appointment to then say anything related to that appointment, whether it's malfeasance, misfeasance, breach of fiduciary duties, death, any of that, go to arbitration?
because it wasn't contemplated, because it wasn't.
And how do we know it wasn't
Because
contemplated?
it wasn't expressed, and because Judge Hallmark ruled, in her ruling, you'll see it, she says specifically that she's not going to rule on anything, any prior conduct. She's only ordering, and she made a ruling before the trial. I'm not sure exactly which exhibit it is, but it says specifically that she's not going to relitigate any past conduct, which means in her language, I'm only going to litigate future conduct after his appointment, which is his accounting. His accounting is not mentioned in this arbitration agreement. To adopt his argument would be unfair to all the other parties in this agreement.
What isn't, you appointed the conservator, and conservator is a legal term that's defined by statute and all the obligations. You don't need to restate all the obligations. Once you're appointed conservator, by definition, all that other stuff you just referenced tags along with it.
Doesn't say that in here, and it wasn't contemplated by
But
the
that's a legal
parties.
conservator. You would agree conservator is a legal term, and the parties understood it was a legal term defined by statute at the time they entered into the settlement agreement, correct?
A conservator is a legal term, yes, but his duties later are not contemplated in here.
But aren't duties of conservator defined by law?
Of course they are.
Okay, so why would you need to then list all the duties in a settlement agreement if you're defining you're the
Because this-
conservator, period. And with that, here's what the statute says, these 20 things you have to do.
You have to presume a lot of facts there in that scenario, Judge. All I'm saying with respect is this agreement only contemplated the dispute over appointment, and the facts, both sides agree. The facts are that the people involved in that dispute were disputing She wanted to be appointed conservator. She wanted to be appointed guardian. He wanted to be appointed conservator. His sister Therese wanted to be appointed guardian. That was the dispute at that time. And that's all they resolved. They didn't resolve future misconduct, supposedly, allegedly, as conservator
But they
or
resolved
guardian.
other things too, right? There are other things listed in the,
That's what I'm saying.
Okay.
That's what was arbitrated, and Judge Hallmark made a determination. Finally, she ruled some things go to arbitration and some things don't. And this doesn't, because this has to do with future conduct of the conservator handling money while he's conservator. Because
Those
the,
were all obligations that he had as conservator as contemplated by settlement agreement.
I'm sorry, I didn't hear the entire
All the
question.
things that you said he then did as conservator were all obligations that he had to do as contemplated by the settlement agreement.
He had to do them
Yeah.
once he was appointed conservator, yes.
So those are also, I mean, the things that you say are breaches of his obligations, those arose, those arise?
The parties have to knowingly give up jurisdiction in an arbitration agreement, and they didn't. And the law in my brief is clear about that. All they gave up was the right to appoint or be appointed. They didn't give up their right to go to court, to have the court supervise an accounting. In fact, this conservator had to submit his accounting to the court. What are you supposed to do? File an objection with an arbitrator? Of course not. He has to submit his accounting to the court. In fact,
Verbiage, any controversy or challenge to the enforcement of this
Enforcement.
agreement, that they didn't give up anything when they agreed to that?
the enforcement of the agreement itself, all the terms in the agreement, whether he would provide the promissory note, did he or did he not? Whether he assigned all names to the accounts in paragraph 5, did he or did he not?
but enforcement of the agreement, part of that agreement is enforcement of
His appointment.
his appointment as conservator, but enforcement of the agreement as conservator. Like you're really parsing the words there to say, look, any challenge to his appointment as conservator, well, part of the appointment means it's not just a title, there's duties that come with that title.
Well, frankly, Your Honor, I didn't write it. It's inartful. But you cannot waive future facts, future wrongdoing knowingly.
Well, you're not waiving, I'm sorry to cut you off, but you're not waiving that wrongdoing. You're simply saying that wrongdoing's to be decided in this forum. And so if, for example, you wanted to do the accountings, you would file a demand for arbitration, or you'd go to the arbitrator and say, hey, we've got a dispute about the accountings.
You would think so, except that. May I-
Help me understand, yeah.
I'm going to help you right now, because this conservator, Mr. Letitia, on September 22nd, 2022, filed his first annual account with the probate court. And he didn't file it up for approval. And we asked him on several occasions, over and over and over again, for supplemental disclosure of documents to audit it. We did it over months and months and months, and we filed a petition finally with the court. He didn't bring up arbitration. He didn't bring it up until the fall of 2023. He spent 9 months while we litigated in court, not bringing this up.
So is that the issue of a
He waived it.
waiver of not conduct consistent with the duty to arbitrate?
That's the point. The point is that I have a list of correspondence from September all the way through January to March, where he and his attorney were slow walking us, where his other friend, the attorney John Cooper, were slow walking us, and they were engaging in court. We went to court. We sat in the conference room. We talked to court staff. We issued subpoenas. He didn't say this should be arbitrated, not until the very last minute.
Understood. And you've got about a minute left
Okay.
for argument.
Well, my
I know
brief, I
we've
think-
peppered you with questions. What are any additional points you want to make
My
sure? that
brief
you're limiting
covers
your time?
quite a bit. Thank you for giving me my final minute. My point was, I asked for oral argument late because Mr. Letitia had asked to supplement the record. And I felt that he was trying to supplement the record with his final approved accounts that were not filed and approved by the court until late summer 2025. Well, we had already filed our brief in June of 2025. And this is the point. He needed 2 auditors to be appointed by the court to work with him to get his accounts filed. And when they were finally filed, that long after they were due, my client said, let's just not object to them. Let's just move forward. We've had 2 different conservators serve since then, and Yola Letizier's finances are safe. Let's leave it as it is. Thank you.
Thank you. You have a brief time for rebuttal.
So just want to go with one item first as to the waiver of arbitration that was brought up. I understanding the timing concern, but waiver requires both inconsistent comment and prejudice. I demanded, that we go to arbitration before the trial by my motion, my emergency motion in August. Trial happened over my objection. Any prejudice from the pre-arbitration discovery is, self-inflicted by hate who chose court instead of arbitration. I still defer back to, the settlement agreement as where this case should be. And I can go through, but it's in my briefs on some of the items that the judge also, the trial judge had, trial court had made in mistakes in the forgiveness of the loan. That statement was never stated. The attorney fees, stating that they're, in the first January brief or order, and then in her secondary, the June order, stating there was not enough information on record to make a decision, and as part of the grounds for my removal. Again, I defer back to this case. In my opinion, for these reasons, I asked the court to vacate the January 17th, 2024 order and the June 6th, 2024 orders, and remand the instructions to refer Mrs. Haight's petition back to the arbitrator. I understand, as your honor brought up, there's other cases pending on that. My removal was prior to all those. And if it pleases court, everything else you seem to have well under, in hand.
Okay. Thank you very much.
Thank you,
Thank you
Chuck.
for your time.
Thank you.
That matter will be submitted. Calling related item number 17, docket number 375802, in Ray conservatorship of IL. Additional parties in council, please approach. There may be some shuffling of seats, I think, in this matter. There you go.
I think I should have brought a stool. Marvin Neubauer, may it please this honorable court, appearing on behalf of appellant Thomas Brennis Frazier.
You may proceed.
Thank you, your honors. So this is, a lot has happened, as your honor had mentioned, since this filing of this case, and I have with me 59 motions and orders in which Judge Richards was removed for bias, just like we allege in our brief. The specific language of those orders says the court has reviewed the motions, considered oral arguments and evidence presented, and finds objectively that there's an appearance of impropriety, such as disqualification, is warranted. It further states that the judge shall be disqualified from this matter, which is the same language presented in all 59 opinions, and from hearing any cases from which Mr. Frazier is an attorney or party. So since we filed this brief, we had made 5 claims, which I know this court said they're familiar with. And I also note that Your Honor asked what's going to happen in this, because it's been so litigious, there's a lot of issues going on. What happens if one case makes the other case moot? One of the big distinctions is that this case is now, if this court chooses to reverse and remand, will be in front of a new judge. And that judge seems to have a very good handle on this case and is addressing the main issue, which is the best interest of the ward. I'm presenting myself for any questions you may have, but we are relying substantially on our brief.
Okay, any questions? No questions? Speaking,
Not right now, no.
okay. Thank you very much. You have ample time for rebuttal should you need it.
Thank you.
Just for the record, I want to represent that I represent Michelle Haight, Edward Nahat for the Kemp Klein Law Firm.
Yep,
As an appellee for the record, she stands mute. Thank you.
thank you. No further questions? Okay. That case is submitted. Moving to docket number 18, or item number 18, docket number 377144. Again, in-ray guardianship of IL. No party is endorsed for oral argument on this matter, and so this matter will be submitted on its briefs. Submitted on the briefs. That concludes our 10 a.m. Window of this case call. We're gonna go into a short recess to give everybody a chance for a break before we start the 11 o'clock panel. All rise. Thank you all for your patience. The crowd thinned out. They didn't know we were gonna sing Andrew happy birthday, Judge Levency happy birthday later at the end, so.
Neither did I.
Welcome back, everyone. Moving to our 11 o'clock case call here on panel number 3 in Detroit. Item number 19, docket number 377142, in Ray minor. G minor. No one's checked in? All right, that case will be submitted on the briefs. Moving to item number 20, docket number 378488, in Ray Harris minors. And no one has checked in on that one. We're not very popular today. That case will be submitted on the briefs. Moving to item number 21, docket number 378012, N. Ray Robinson minors. We have a remote oral argument that has been granted. Give us a moment while we get that up and running.
Good morning, I'm Phoebe Moore.
Good morning, Ms. Moore. Give us 1 minute while we're trying to get our video. There we go. We've got you on video.
May it please the court, Brandon McNamee on behalf of the appellant, Ashley Story.
You may proceed.
Thank you. Your honors, I'll start with, why we're here. The court rules allow an appeal for any removal, and it uses the word any. So the error in this case is the statute at issue and the court rule at issue. Some pretty strict requirements as to what has to occur before an ex parte order can be signed, removing a child. And I don't think that's by accident. I think when you remove a child, especially when you're dealing with an ex parte order, an ex parte order is kind of a little tenuous as it is. you know, the other side, the parents, they don't have a chance to defend themselves. And the statute and the court will both say that it has to be by a petition. And you got to put this stuff in writing or an affidavit. And based on those facts, you can remove. And there's been a concession by the other side that that did not occur here. That did not occur here. And their basically their response, my reading of it is, well, she's a horrible parent, and they use horrific, which I don't agree with. So it's enough that they can just come in, have a powwow in chambers, have a discussion, show some photos, and we have an order signed.
The ex parte order, I mean, it did include some information
Correct.
and it includes some attachments.
Photos.
Well, and a document, right? A one-page summary of information.
It wasn't even signed, correct?
It wasn't signed. I understand it wasn't signed as, you say that because it wasn't an affidavit, right?
Correct.
Is that what you mean?
Yeah.
Okay, yeah, it wasn't signed. And then once that ex parte order is, if I get the terminology right, is submitted or entered, then a hearing has to happen in 24 hours,
Which it did happen,
which it did.
but there was no basis or petition or underlying.
Yeah, the
thing.
petition came later because you don't have to do a petition, right? You can do an affidavit.
Or whatever, yes,
Right.
correct.
It's one or the other. It's not, you don't have to do a petition. Okay. And then the copy of that ex parte order with the whatever information, photos, the one page, was provided to the respondent. I don't know, I'm gonna get the verbiage right. The mother and the father
What the term of the ex parte hearing? I mean,
at the hearing.
the parents weren't even there, and the attorney didn't have a copy of anything. So you had the removal hearing right away.
Yeah, at the removal hearing,
Yeah.
there were parents there. Were
No, not the first hearing.
that afternoon?
I don't believe so. They were at the preliminary hearing that occurred later,
The next week.
next 5 days later. Yeah.
Yeah. My understanding from the record was that the father was available by Zoom, but that his attorney wasn't there. And that the mother and her attorney was at that first
I can
Friday
check.
afternoon proceeding. And the person on video is nodding, but okay. Well, it's okay.
I'm trying not to nod.
It's okay. Well, no, I understand. So I guess
Okay.
I'm just trying to understand the chronology. So your point is the same. There was no affidavit and a petition wasn't filed. I understand that. However, once that ex parte order was entered, there was information in there. In the text of the ex parte order as a one-page text attachment and photographs. And I guess what I understand there's some ambiguity here, but my understanding was that ex parte order with that one-page attachment and those photographs were provided to the mother and her attorney, and probably not to the father because my understanding is he was in jail and appearing by Zoom, and that father's attorney didn't show up that afternoon for legitimate reasons, not. So I see your point, which is, but it's not like, I guess where I'm going is, it's not like there was a mystery, right? That afternoon, that Friday afternoon, when there was an initial hearing on the ex parte order, it wasn't hidden from anybody, is my understanding. Can you speak to that at all?
Well, first of all,
The reasons weren't
you're
hidden.
referencing events that have already occurred after the order has already been signed.
Yeah, there was a hearing a few hours later.
The error is you can't sign the order without that. I mean, let me ask you this: if you're ruling on a motion for summary disposition in a third party injury case, auto accident, are you going to excuse the other side when they don't submit a valid affidavit in behalf of their support? Are you going to say this statement that you provided without an affidavit is good enough, or are you going to say, you know what, the court rules require that you have an affidavit that's signed and executed and sworn to, and then I can see your evidence? Because I've been in court and we follow the rules when it comes to some pretty other things that aren't as necessarily important as removing a child from the parents.
Talk to me about why, let's say, the affidavit wasn't submitted, wasn't signed. I think we're all on the same page there. Doesn't this go to harmless error? Why is this not harmless error? Because there was sufficient evidence on the record to justify jurisdiction and adjudication.
Sufficient what legally admissible evidence, what evidence, just the statement that's typed up. I submit that they have very specific rules that have to be followed. And when it comes to removing a child, you have to comply with an affidavit or a petition. It's not that hard these days to get an affidavit.
So you'd be arguing for strict compliance on those. They must be strictly complied. Harmless error should not enter into the equation.
Yeah, because if you're just allowed to walk into chambers, which occurred here, have a discussion without a paper trail, have something that's not sworn, submit pictures with no context, and then make the ruling.
These are expedited proceedings, right? The court rules do allow for this to happen in very short turnaround.
Don't forget, we can remove the child. The law enforcement can. And then we ask that the rules be followed. I mean, if you want to say that it's not important when it comes to the fundamental interest of removal, and I'm not saying you're not. I'm saying
I think the difference is you're saying it's some sort of nefarious that, oh, they go into chambers and no context. That provision, that process is actually provided for in the rule, right? Because if you submit an affidavit, that's not going to get filed. That's going to be provided in chambers. So that you say that as though it's nefarious. Your point, which is a good one, is essentially, let me ask you this, sorry. If the page attached to the ex parte order had been signed under penalty of perjury and was an affidavit, would we be here?
It has to be an affidavit. It has to be an affidavit. You have to follow the rules.
Okay, so we wouldn't be here.
Let me ask this. Is it a hard rule to follow? No, it's not. It's not a hard rule to follow.
And that's what goes to harmless error.
And like, why do we have people raise their hand to give an oath? Why do we ask people?
I understand.
I mean, when we take a plea to littering now in district court, we swear the witness in. We make them swear to the facts that they're getting are true. And when we allow someone to just, it's not just the court rule, it's the statute. When we allow them to excuse that, we're circumventing the rules and we're saying it's good enough to just give a statement. And what we're doing here is a fundamental liberty interest. I'm just saying, like, we have these standards across all of our court rules, and these are civil proceedings. And we don't give excuses. We follow the rules on all sorts of stuff when it comes to affidavits and swearing testimony. And I can't for the life of me thinking this is an appeal of right. I mean, the Court of Appeals has said this is an important enough order that we're going to give someone an appeal of right on this order. And I'm saying when you don't do the affidavit, when you don't do the petition, and the petition just has to be signed. I mean, you can just type it up, do 6 paragraphs, and then you have a basis. But when you just type out a piece of paper, attach some photographs, and then use that order, that's a problem.
But if that page had been signed and said affidavit at the top and under penalty of perjury, then it's okay.
And notarized. Has to be notarized.
Under the affidavit statute.
Okay, so I said it's an affidavit.
Yes, it either is an affidavit or isn't an affidavit. And why does the court rule say that it has to be a sworn statement?
So your best argument of what you're saying is fundamental rights, strict compliance,
Correct.
harmless error shouldn't apply.
I mean, I think you're opening the door to, if you don't have to do an affidavit, if you don't have to do a petition, what's to just walking in and having the order signed?
Does it matter what happened the following Wednesday?
I want to address that too, yeah, because there are 2 things. One, they keep talking about probable cause and said they were going to file a transcript. First of all, this determination on placement isn't probable cause, it's preponderance of the evidence. Removal has to be found by preponderance of the evidence. And there are 2 things that have to happen at a preliminary hearing. Okay. The first is, and it's in the order, it's listed right there. First, you make a probable cause determination on whether the petition could be authorized. And then in a completely separate section, you then hold a hearing on placement. So just because someone waives probable cause doesn't mean anything. Nothing's been waived, because in this case, I've read the transcript from the preliminary hearing. They had a hearing on the placement and the attorney objected to the removal. So I don't know how we could have a waiver when we had testimony and a hearing and objection to the removal, because there's two separate things. And in Henry Williams, I have two cases pending in the Court of Appeals right now, because sometimes judges make the mistake and they assume that the probable cause standard applies to removal findings. It does not. Henry Williams, which is the published case on the statute, has gone over multiple times that preponderance of the evidence applies to a removal decision. And the reason that preponderance of the evidence applies is important, because it tells you when you're authorizing the petition probable cause standard. When it says you're using an ex parte order, it says a reasonable cause. And it's weird. Both the court rule and the statute say reasonable cause for ex parte. Then the statute and the court rule say probable cause for authorizing the petition. And then absolutely no standard is given for placement for placement or removal. Now, in a civil proceeding, the default is preponderance of the evidence. That's, and I've pointed that out, but that's how it lies out in the statute. And it's separated by sections. You know, when they look at the preliminary hearing court rule, the first determination is authorizing the petition, and then it talks about probable cause. And then in a completely separate subsection, it talks about removal and cites no standard. And it's the same thing in the statute. Probable cause, and then it doesn't cite a standard. And they're separated in completely equal subsections. So, but in any event, that's what happened here. We don't need a hearing on probable cause, but we're going to fight you on removal, which is exactly what happened at the next hearing. Now, all of this is irrelevant because these are all proceedings that happen after the order I'm appealing. So your only determination, in my opinion, is I had a right to appeal this ex parte order because it didn't comply with the statute, didn't comply with the court rule, and I appealed it. But I'm responding to the argument that they made.
And my question, which is, does what happened the next week matter? And your answer would be no.
For the reasons I just said, yeah, a very long-winded answer. But yes, the answer is no for those reasons.
Anything else before we hear, and you've got some time for rebuttal?
I'll just save my time for rebuttal. Thank you.
Okay. Thank you. Counsel, please state your appearance.
Good morning. My name is Phoebe Moore. I'm here on behalf of the Michigan Department of Health and Human Services. May it please the court. Certainly, I agree as to the position of brother counsel. That is that there was no petition or affidavit of facts presented that day. And that, of course, could be read as, violative of the statute, Michigan Compiled Law 712A.14b. We've gone over that. But Your Honor, is just going directly to your questions this morning, which are certainly valid. This is completely a form over substance argument before Your Honors. This is an argument before this panel to say form is more important than safety of children. So we have to follow the rules, no questions asked. And are you going down a rabbit hole to say, hey, this panel from the Michigan Court of Appeals on today's date finds that you don't have to have an affidavit or a petition? No, you're not. You're saying, looking at this case and these facts specifically, we don't, encourage or authorize any violation of the statute. Of course you don't. But in this case, the question before the court is really under Williams, and that's a 2020 decision where this court looked at really harmless error. The specific question is this removal grounds for reversal? It has to be inconsistent with substantial justice. So in other words, you can have an error, but does that error amount to inconsistency with substantial justice? You know what the facts are in this case. We all know them. Without a doubt, this mother left the children in a bathtub for 30 minutes. She admitted it. 19-month-old kids.
Let me ask you this. I'm sorry to interrupt you, but
That's okay.
I think opposing counsel has a point. An affidavit isn't hard, right? And
Right.
the other is, I think, let's just think about the purpose of an affidavit. You want to make sure the information, someone's attesting to it. And so that the judge who's adopting it as part of the ex parte order has some confidence in it. Why wasn't an affidavit done? And does it, like, how did the information get to the court to be included in the ex parte order? Again, if it's in chambers, that's, again, not nefarious per se, but it does raise the question of kind of why it went down this way. And even if we were to find harmless error, my concern is, you're right, we wouldn't have to categorically say that this is okay. But at some point, if courts across the state are doing this without affidavits, and if it's always harmless error to do it that way, that's a problem, isn't it?
Yeah, it is. And I completely respect that, Your Honor. I just don't think this is the case in which you can do it based upon the clear facts of neglect and abuse that we have, and really the waivers that occurred subsequent thereto. But I do want to discuss this, and I'm going to go a little bit off the record. So if anyone on the panel says, Ms. Moore, shut up, stop, you can't say this because it's not in the trial court record, I understand. I was trial counsel for 20.
Are you going to go, I guess I just want to stop you. Are you going to go to the disposition of the case in the subsequent weeks or months?
No, I'm going to talk to you about credibility and trustworthiness. So as to your specific question of why do we need an affidavit? We need an affidavit, and that's part of the statute because we want something trustworthy before the court that they can believe in. That's why we want something notarized. I can attest to you that I was a practicing lawyer for 25 years in Tuscola, Sanilac, and Huron County. And so I can tell you the room that this referee is sitting in. I can tell you that Colette Thady from the DHHS and her caseworker, who was a former caseworker for my caseload under Sanilac DHHS, had just moved up to Huron County. They investigated this together. They went into the courthouse together. It was a Friday afternoon. If you look on the calendar right now, the court can take judicial notice of that. On October 24th, it's a Friday. And if you look at the petition that I attached, the petition is actually signed on the 24th by Ms. Thady, but she didn't file it until the next week because of the weekend. And so this referee knows Colette Thady. She's probably been doing CPS work for 25 to 30 years. I've had a couple of cases with her. So now, does the referee have what it can trust as true, even though we didn't take the 2 seconds to somebody go upstairs to the clerk's office and sign this in front of a notary?
Well, what prevents, I guess, counsel, you're listing a lot of things that A, aren't in the record, and B,
Yeah.
are like, well, this person's trustworthy, this person's trustworthy. Well, none of that's in the record. And so you could have, A, it's not in the record, but B, you could have untrusty and not good people, right? You're saying these people are great and they do their jobs and they know each other. Well, the exact opposite is true. And that's why we have the rules. Isn't that true?
Yes, I'm not going to argue with that.
Yeah.
But this referee has been there a long time and knows these caseworkers. And you had the photos. They filled out a JCO5, which is the order to remove, and simply didn't bring the petition. I can tell you that my she took over for me, Miss Wheelahan. She was trial counsel, and she explained to me, and she sent me the order with the pictures and the handwritten statement, Judge, that you pointed to and said this is what was handed to the referee on that Friday.
Yeah, let me just pause you for a second. I believe Judge Cameron had a,
No, it's all right.
Okay.
No, it's all right. Thank you.
okay, go ahead.
No, so just continuing on that point, just because I think the question was earlier, why do we need an affidavit? And that's why, and in this case, there was trustworthy individuals directly there in front. Isn't it almost better than an affidavit or a petition that these workers took the time to go right from the hospital to the courthouse because it's Friday afternoon? I can tell you that this new attorney, Beverly Wheelahan, she's outside counsel. They don't use the prosecutor's office there. And they were going through that changeover, that the prosecutor's office was no longer handling the NA files and they used outside counsel. Yes, again, I'll admit to you that it was violative, but in this case, we have clear indications of abuse and neglect. We've got caseworkers directly telling a member of the local judiciary, the referee, that their hands and feet were burned, and law enforcement already removed them. So there's simply.
Are you suggesting that harmless error should be applied when it's all child abuse is bad, right? Or situations like this, but because it was so severe in this case, then it excuses ignoring?
No, I'm suggesting that the facts are simply that clear. And so these children would have been removed no matter what with a petition that day. They would have stayed in the hospital that weekend. In fact, they did. And so is it inconsistent with substantial justice? Was this mother's substantial rights somehow affected because of the fact that we didn't have an affidavit. I don't believe they were. She hasn't met that standard in this case. And that's really the test before your honors, and that's under that Williams decision, that 2020 case that I've cited. It's also, of course, the court rule. And I think that really settles the day in this matter. And the court can certainly couch its opinion that you're not advocating for any type of violation from any statute. But in this case, because mother did appear that afternoon, and counsel, or excuse me, your honor, that I did cite the transcript where mother and her attorney were present, and that's in that October 24 transcript. And I did cite that in the brief. But yes, all parties were there except father did not have counsel. Again, I don't think you're opening the door for continued violations, but at this time, in this case, the reversal would again seem entirely inconsistent with what we're trying to do with what's happened in this case since that time. But in that record of the transcript that I did file, I did order and send it in, your honor, for the final preliminary hearing. Mother's counsel objected to the removal, but she was focused on getting the children placed with the relative, and that's why. And furthermore, she admits on the record she was going to offer a plea that day. So again, it doesn't take away the violation, but again, mother has not met her burden that this is somehow inconsistent with substantial justice. Mistakes happen. They happen across the board. They happen in small counties and big counties. But ultimately, under the Michigan Child Protection Law, we need to protect children, and that's exactly what this court did.
Okay.
Thank you.
Thank you. Counsel, you have a few minutes for rebuttal, should you want it.
So if we're going to expand the record, the one thing I heard was that the referee had been there for 12 years.
Irrelevant.
Yeah. But it can also show that this wasn't in isolation, right? I mean, that this has been going on and it been done.
Understood.
Yeah.
Understood.
So, I mean, I think it goes to what's inconsistent with substantial justice is that this is why you follow the rules, because if you don't, you get these mistakes. And let's talk about what inconsistent with substantial justice. It's almost like asking a jury to look at reasonable doubt. I mean, you either feel that it's inconsistent with substantial justice or you don't. But I don't think it's as bright line as the route opposing counsel was going down. This is a bad parent. There's always going to be removal, and that this needed to happen to protect the children. You know, I need to fill the record in with what happened here. Is that, you know, we have a young mother who's got two 19-month-old twins. They're in a little bit of bathwater. You know, she gets distracted in the living room. She's got another 7-month-old in the house, and the dad's in jail. These are all this is all facts in the petition. I'm not expanding the record. You know, one of the kids, they're playing, the two twins, turns on some hot water and gets burned. And the mother is distraught and rushes her kids to the hospital. And you know, good parents get distracted and make mistakes. To say, you know, I disagree. I cringe at the word horrific. And when you're asking a parent who comes in the court and you remove their children from them, and then you ask the parent, you got to do X, Y, Z, and you got to do it perfect, and you got to get along with the caseworker, and we're going to give you all these lists of things to do, or we're going to terminate your rights. I don't think it's too much for the parent to say to DHHS, you have rules too.
The bath incident prompted the ex parte order, but it wasn't the entire basis for the petition. Am I right?
The ex parte, the
bath incident you focus on was the basis for the ex parte order.
Correct.
But it was not the only basis for the petition.
The petition was authorized later. Yes, they had facts about the dad. They had facts about bed bugs. Those are all later put in the petition. Yes. And then, but the problem with, of course, the next orders is they all focus on the original findings that were made based, because that's part of the problem why it's inconsistent with substantial justice. Oftentimes these orders, and specifically in this case, the fact findings are continued. right? And they always say that these are continuous proceedings, continuous proceedings, continuous proceedings. Well, how do these, because
But isn't that in part, the purpose of the statute says, look, when you're talking about severe situations and protecting children, sometimes you have to move quickly and get things done quickly, and they may not be complete, may not be a full set of facts. And we have to ensure that there are legitimate reasons, but you have to move then quickly afterwards to amend the petition, get the full hearing, all those types of things. I mean, I get the countervailing concern about parental rights. It's a very, very important right and part of it, but the statute and your criticism of the statute ignores that the reason why those things are in place is because it's for the interest of the children who cannot protect themselves.
correct, but they also allow for removal right away without any ex parte order. They allow the police officer to remove the child. They remind the police officer to take the child. But then at that point, once the court gets involved, we got to do things a certain way when we're involved. When the lawyers get involved, I think the standard heightens a little bit. I think you make people swear to the facts that they're submitting, or you don't. And you got to remember what happens when you're wrong from the start. I mean, the very first significant order that's signed is the ex parte order, and then everything flows from that. And don't forget, like at the next hearings, the contrary to welfare stuff and the findings are continued based, and they write that right in the order. It's continued on based on the prior order. So let's be accurate and thorough from the start.
We understand.
Yeah,
I think you're starting to repeat yourself.
Yeah, that's fine.
No, they're valid points, and I don't mean to, I'm not dismissing them at all. I just think we're covering ground we've already covered.
Yeah, no, I appreciate it.
Anything else, that's responsive to
No.
council's argument?
No.
Okay, thank you.
Thank you.
Very, very well argued and briefed on both sides. Thank you. That matter will be submitted. You get to stay on, camera, I believe, council?
Yes, I'll stay.
Item number 22, docket number 375741, In Re Shiflet Minor. Council? We have 3 parties here today. Counsel for the appellate, you may begin and restate your appearance for the record.
Morning, Your Honors. Again, Alona Sharon on behalf of the petitioner appellant, Mr. Shiflet. I will try to reserve 2 minutes for rebuttal if I think that it's needed.
Yep.
Your Honors, I'm not going to rehash everything that's in the brief. I do just want to respond to a couple points. And then, of course, if Your Honors have any questions, I'm happy to answer those. And I'm not even going to touch on each issue because I know the court is very familiar. I do want to touch on the first issue, though, that the impeachment testimony from the complainant, or AS in this case, was not substantive evidence. And Mr. Mashney kind of responds in one way, Ms. Moore responds in a different way. And so I do just want to address that. First, Mr. Mashney brings up that these statements from the child would be admissible, an exception to hearsay under 803-24, subsection 24. So 803-24 doesn't exist anymore, right? It was taken out of the rules of evidence in January of 2024 and sort of recodified as MRE 807. Although the language, I believe, is verbatim. I think it's almost exactly the same. So we really don't have a ton of case law in 807. We have to still look to 803-24. And there are recent cases from this court, albeit unpublished, that I thought were very helpful. One in particular, which is the estate of Donald Gracie Sr. versus Woodward Hills Joint Venture. That's docket number 361082, November of 2023, where this court suggests that there is case law from this court indicating that it is a requirement for the purposes of 803-24 that the declarant be unable to testify, citing to People v. Lee 243 Mishap 163, a 2000 case out of this court. And of course, that's not the case here, right? AS testified, but she testified that she was never sexually abused. Over and over and over again, she told the court and the jury, he did not do this. I am mistaken. This did not happen. And so 80324, I think number one doesn't really apply for this reason because the declarant did testify, but also because it just can't meet the factors that are set out in, I believe it's People versus Cat 468 Mich 272, a 2003 case. Primarily because there is no spontaneity to these statements, right? They were elicited during a care house interview, so they're not spontaneous. And I think that our cases recognize that the declarant's actual testimony, right, is the best testimony. It's what comes from firsthand knowledge. And if AS was there to testify, there's no reason for 80324 to apply. So for that reason, I think Mr. Mashney's argument has to fail. Ms. Moore references MRE 613, which has to do with impeachment of witnesses, and it's what authorizes a party to impeach their own witness. I don't at any time argue that they can't impeach AS. They absolutely can. The problem is that that testimony is not substantive. It's only for impeachment, and that's where the problem lies, is that counsel did not ask for the relevant jury instruction, and the court did not provide it. So either it's court's error or it's ineffective assistance of counsel.
What about the argument that counsel, by presenting and confronting AS with her prior recorded recollection, that it was an ability to refresh her recollection, that asking her about her prior inconsistent statements is refreshing her recollection of what was prior?
Well, so she would have to say that she doesn't remember, and then you would have to give her something to refresh her memory, whether it's a document or something to look at. But she didn't say that she didn't remember. Her testimony was, I said this, but it's not true. So it wasn't a case of if I said, Your Honor, do you remember that at the 10 o'clock call, you asked me this question? And you say, no, I didn't ask you anything. And then we show you a transcript to refresh your memory. That would be that scenario, but that's not what this case was. What this case was is that she was questioned about the details of the alleged sexual abuse. And she said, no, I was not abused. At which point the attorney says to her, yeah, but don't you remember back in Care House when you disclosed certain allegations? Tell me what you said at Care House. Tell me what you described at Care House. That's not refreshing recollection. That's saying, give me impeachment for your statement now that this never happened. So I think that's very distinct, respectfully, Your Honor. Thank you. I do want to turn now to the claim of ineffective assistance of counsel as it relates to the counseling records. So just to be clear, I'm not suggesting necessarily that the counseling records should have come in at trial, but this attorney for Mr. Shiflett certainly had oodles and oodles of information from those counseling records that would have been helpful to Mr. Shiflett. And I think primarily, number one, how quickly this child recanted. We know that within 72 hours, she was telling her therapist that she did not believe that the sexual abuse happened. But the brief contains, and I listed, I'm not going to repeat it for Your Honors unless you really want me to, all of the information that was helpful to Mr. Shiflett in those counseling records. I think almost most significant is her statements and multiple statements to the therapist that she believes she incorporated other person's disclosures into her memory, right? She had gone to a church retreat where people disclosed sexual abuse, and she had just been to that retreat almost immediately prior to this teeth pulling, right, where she discloses, or that when she remembers from childhood that she would often hear other people's experiences and make them her own. That's major. I mean, this is a juvenile. We know that they're suggestive. We know that their memories can be unreliable. And this child is telling the therapist, I think this is what happened. I may have been abused, but I don't think it was my father. And I think there's a very distinct likelihood that I'm taking other people's stories, other people's memories, and I have sort of made them my own. And that never comes out in this trial. That there can be no strategy to that, where this child admits to her therapist that I think my memories have been corrupted and therefore unreliable. That is ineffective assistance of counsel. And the last point, Your Honors, that I would like to make has to do with the sufficiency. And I feel like this argument will probably get some reaction from the court. I don't know if it already has in your private discussions, but turning to pages 29 and 30 in my brief, the grounds on which the right termination happens. There's three grounds basically, and I lay them out in the brief about why the termination under each ground is improper. And I just want to touch on that. Because I think Mr. Mashey and Ms. Moore kind of dance around the argument, is that right under MCL 712A.19B sub 3 sub B sub I, the court has to find that sexual abuse happened and that the child will suffer from injury or abuse in the foreseeable future in the parent's home. Okay, even if your honors, okay, even if the trial court is convinced that Mr. Shiflett committed these sexual acts, the undisputed evidence is that for 10 years, this child did not suffer any abuse. There was no sexual abuse for 10 years. She was bonded to her father. She loved her father. She wanted him back in the home. The therapist corroborated that. And so foreseeable future, how can the court make a finding in the foreseeable future that this child will be harmed when the child wants the father at home, right? It's not just a question of being bonded. It's a question of time, right? Of proximity. We have 10 years undisputed of this child not being abused, even if you believe that the abuse happened. And I understand that there is maybe some discomfort about that argument, but the language in the statute is what it is.
Yes, required, did she not, therapy for anxiety and depression? Is
right,
that
but-
correct?
Yes, and she started therapy before the disclosure at the dentist's office. And the record, in my opinion, very much suggests that the depression and anxiety is something she was experiencing well before the disclosure, and that her parents had
Couldn't it be because she was being abused prior to the disclosure that caused her the anxiety and depression?
I think that's conjecture. There's nothing in the record to suggest that.
And what about her reports of not feeling safe in the home?
Right, so that's the statement that she made at the dentist's office, that she didn't want to go home because she didn't feel safe. And within 72 hours, she recanted those statements. We know that.
After speaking to parents and grandparents and all of that.
Again, I don't believe that there is anything in the record to suggest that within those 72 hours, first of all, the father, so right, we're not waiting for the mother to report. The dentist's office reports immediately because she makes these disclosures at the office, and obviously we all know they're mandated reporters, and he agreed to leave immediately and not have access to his children. So Mr. Shiflett certainly couldn't have tainted anything, and there is no evidence to suggest that either the mother or the grandparents discouraged her in those 72 hours. There just simply isn't. The second ground, MCL 712A.19B sub 3 sub J, Your Honor, also requires that there must be a reasonable likelihood that based on the conduct or capacity of the parent, the child will be harmed if returned to the home. Again, even if you believe that the abuse happened, the undisputed record is that for 10 years, he was a devoted father, a caregiver, a provider for the family, and the one that this child was most bonded to. And finally, under 712A 19B sub 3 sub K sub little I, termination is appropriate if the parent abused the child, the abuse involved criminal sexual conduct involving penetration, and the child will be harmed if returned to the parent's care. For the reasons I've just stated, I don't need to repeat. The evidence was insufficient. And I understand that that might leave a bad taste, but the statute is what it is. The danger has to be immediate and foreseeable. And with this record, it was insufficient, Your Honors.
Thank you. You have time for rebuttal.
Thank you, Your Honor.
I don't think we have any questions at this time, but. Counsel for.
I can go?
Yeah, she's gonna go first? Yeah. Okay,
Okay.
Yep.
Good morning again, Your Honors.
just check it. Go
My
ahead.
name, my name is Phoebe Moore, and thank you for allowing me to attend via the Zoom application this morning. I just want to address some of counsel's comments straight away before I get into some further argument. And just the point being here that counsel might respond to you this morning, Your Honor, that that's conjecture. Isn't everything she just said conjecture? In other words, what if the counseling records came in? What if this child was abused by someone else? What if those statements came in from the therapist records that she was having second thoughts or she was recanting here and there? Isn't that also conjecture? In fact, all of this is conjecture. But we have to leave a case in the province of the jury and the trial court judge. We have to give them all deference. That is according to the case law, of course, controlling child protection law. And so that is why this decision should be upheld. And furthermore, in this case, when we're talking about the CAC interview and these counseling records, where are they? How can we tell if this kid's testimony is even inconsistent with the CAC interview if we don't have it? How can we tell if the counseling records would have potentially helped father if we don't have them? I don't think that the appellant has met his burden this morning that is proving to you that there are these inconsistencies or that these records would have been helpful because we simply don't have them before us to consider. So that's my main point there as to the documents. But in terms of this inconsistency, I truly think that's the only thing worth discussing this morning. When we talk about jury verdicts, again, we need to leave them and protect them as they are so important to our system. And likewise, with the termination of parental rights, the trial court judge found clear and convincing evidence and, of course, found a preponderance of evidence of the best interest factors, clear and convincing evidence, excuse me, of the statutory grounds. And I'll come back to that because counsel ended on those three subsections of the statute, and I think it's important. But I really want to focus on this inconsistency. When I look at this record as a whole, I don't see what's inconsistent. First of all, I don't know because we don't have a CAC interview to say it's inconsistent. The father, as I pointed out in my brief, wanted to have this interview played for the jury. Of course, we have a statute directly on point that says that CAC video can't come in at adjudication. But nevertheless, I just don't understand father's position. It's so backwards and forwards. And furthermore, it's waived. There wasn't a single objection by father during the trial as to this inconsistency argument. I think the guardian ad litem details that fairly well in his brief as well. I touch on it in a footnote, but he forfeits his argument to come before you and say it's inconsistent. But I don't want to give in to this idea that there's some inconsistency because I simply don't see it. The first thing the kid says when she's asked, why are we here? She says, because I allege my dad sexually assaulted me. No one at that point said anything about an interview. And so if you really look closely and read her testimony, there's so many things that aren't even connected to the interview. First of all, she admits she claimed that he sexually abused her. Then later, she talks about things like the discussion with him about him being a pedophile. That was only a year prior to the wisdom teeth incident. She talks about putting the crayon in his penis. She talks about the glow sticks. None of those were in reference to some type of interview or what counsel alleges is a prior inconsistent statement. I don't know if it's prior inconsistent because at the CAC interview, apparently she said, my memory isn't clear. I'm not sure, but I think he did this. At least that's what I think. I don't know. I don't have it. So again, it's all somewhat inconsistent across the board, right? And then she goes to a counselor and says, well, today I'm 75% sure it happened, but next week she's 75% unsure. Those counseling records would have destroyed father's case. I can assure you of that. If
Counsel, what about Sharon's argument about relying on law of 803-24 and that the prior counseling records used to refresh her recollection that was improper because it was inadmissible hearsay?
I don't agree or disagree, Your Honor, and I did not look at that. So that was that question is best for the GAL. So attorney for father did point that out that was his argument and not mine, because I don't think but honestly, I should answer your question directly. What my opinion is that I don't think it's hearsay because she's on the stand.
Understood.
So I don't know if that helps. In any event, but I just don't think it's inconsistent because we have direct statements from her. Furthermore, again, similar to the last case, I guess if we look at harmless error at all, and I think I noted it in my brief, how did this inconsistency or this failure to have some kind of curative instruction, which we all know wouldn't work, however many of us have used them and they work and they seem to slap you in the face when you use them, and nevertheless it wasn't preserved. But even if that's the case, and we say, okay, the kid's testimony, just throw it out. There's so much other evidence in this case, and I think that's where counsel really misses the boat here and tries to keep that from this court, which is the mother admitting that, yes, my daughter said it was just a blowjob. No objection on hearsay. That could potentially be hearsay there, Your Honor, because mother is stating what the daughter told her. The trooper saying, yes, we investigated. Yes, I found evidence of sexual abuse. And yes, I filed the CSC1 charges. The worker, I mean, you've got so much other evidence that this in fact occurred. So I just don't think that this one instance of inconsistency or even the child's testimony affects the ruling in this case. Please note that the verdict, the finding of jurisdiction by this jury, Your Honors, is that the child was subject to a substantial risk of harm to her mental well-being. The jury did not find abuse under subsection B of the statute that we're looking at in terms of jurisdiction, which would be sexual abuse or criminality. And that's significant to me because the jury found this guy's crazy. He's somehow trying to punish her or recant or forcing her to recant or creating this environment that her mental health is at a substantial risk of harm. They knew she was in counseling. So when you look at that and then you couple that with the trial court's findings, and now I'm going to move into the statutory grounds under termination of parental rights, they're entirely consistent with this record. So the trial court comes in after disposition, having listened to the whole trial, having seen mother's, argument with the trooper, which was absurd, and putting that on the record, having seen all of this kind of pressure from the family, if you will, and in their Christian beliefs or whatever the heck else they were pressuring her with, the court could very easily find those statutory grounds. And the statutory grounds are clear and convincing evidence that he sexually abused her, not beyond a reasonable doubt, not a criminal standard. And then subsection J is that he doesn't have the capacity and disposition to provide for his daughter, and that there's a reasonable likelihood, and I'm going to come back to that. And then finally under subsection K, which is of course the sexual abuse of the CSC as well. And so again, but clear and convincing evidence of statutory grounds. So even if the trial court found under subsection J that he doesn't have the capacity and disposition to care for this child, that would be enough. You only need one subsection, even if we threw the clear and convincing evidence of criminal sexual conduct out the door. So it's still there, and the trial court can disagree, but the trial court listens to all those witnesses. We have to give deference to that trial court. It's really hard for all of us to sit here and, quite frankly, this is conjecture. What we're saying is this could have happened, this would have happened, this could have happened, but they were all there, and we have to protect that. So in any event, I've been before the Court of Appeals for years now talking about this foreseeability issue, reasonable harm in the future. It's under every subsection under the statute. And quite frankly, if this court today finds, oh, there was sexual abuse, but yet we don't have foreseeable harm of future harm, that would really throw all sexual abuse cases out. I mean, to sit before you and say, and counsel's right, I do take issue with that argument. She was abused from 5 to 7 years old, and a year ago he said, sorry if I was a pedophile, but I can take care of you now because I have a bond with you for the next 2 years of your minority. I don't believe that there's any type of reasonable tie to somehow she's going to be safe in that home. She said she wasn't safe. She didn't feel safe at the dentist's office. And again, that's not inconsistent. That wasn't in a CAC interview. And she's been in mental health counseling for how many years? And this father's supposed to help her because he hasn't admitted anything and has no remorse. So a trial judge has that within his or her province to say, based upon all of these facts, quite frankly, weird as they are, this guy still presses to get into the home, to get into the garage, to talk to his wife. He won't leave her alone, that he is going to just be present around her. And that is going to be create an emotionally unfit environment for her for the rest of her minority. And she needs that safety and permanence. And so there's beyond the necessary evidence on this record to let this decision stand. In other words, there's no firm conviction on this record that the findings by the trial court judge on termination and best interest should not stand. The best interest is a preponderance of evidence. And again, with a criminal sexual abuse case like this, we're going to have best interest even with a bond that it is in this child's best interest. She in fact said she felt better after testifying. But she needs a space to be free. Your Honors, please uphold this decision. Thank you.
Thank you, Counsel.
May it please the court, Ramsey Mansion, guardian ad litem for the minor child in this matter. Just a few clarifications on appellant's statements. One, on October 7th, AS disclosed at the dentist office. This case didn't get before the judge for the preliminary hearing until October 23rd or 24th, I believe it was 24th. In that time, I agree that Mr. Shiflett left the home, but the testimony at the preliminary hearing and the testimony throughout was she didn't stop Mr. Shiflett from contact with the minor children until the court told her she couldn't. She just moved him out of the house. He was still
Mom.
coming.
Mom, right.
He was still coming to the house every day for a few hours before he went to her parents' house. So yes, I agree that he did move out of the house on October 7th or 8th. But for her to say that he didn't have any contact with the children after that point is incorrect, because the testimony at the preliminary hearing and at all subsequent hearings regarding mom stated she didn't cut him off till the court told her she had to. In looking at 803 MREA 803-24, my point in putting that in there is there had to be it's a judge's abuse of discretion to sustain an objection, which was never happened when these testimony came in. So that would have been one of the reasons the judge could have let it in. It's not that that's the end all. That's one of the reasons the judge could have let it in. They redid 807, 803-24. I must have missed that when I was reviewing it, and I apologize to the court for that. But as counsel said, you still have to use the case law regarding 803 because it's the same language. So I apologize if that's been misstated, but that's just another reason. But there was no objection, so it's waived anyways. In regards to the sufficiency of the evidence, the argument is, had these counseling records been used, whether through the counselor, which was never made an expert, or through AS, the fact is she flip-flopped in these counseling. She wants to point out, yeah, within 72 hours, she says, I don't know if this happened. And then throughout the counseling for the next year and a half, she's like, yeah, it could have been 50%. It could have been 70%. He did it. So to say that he didn't do it and that's insufficient evidence and is incorrect. It wouldn't have helped him. It clearly wouldn't have helped him when you look at it. The other thing I wanted to point out, just for clarification, in reviewing this again yesterday, I realized the appellant's exhibit of them counseling records, which were never in the record, is missing pages 31 to 53. I don't even know what's in that. I don't have it. The one I have, just for the, only had the first 19 pages at the time of trial, a year ago. A lot of the stuff, I think, was even after the trial that she added on. It might not have been. So, but I'm missing page 31 through 53. But,
Other points, counsel?
pardon me?
I was just asking, I thought you were
I
wrapping
have
up. I was just,
one or two other points.
yep, go ahead.
As far as sufficiency of the evidence, one, this is a jury's determination. The fact that she said he didn't abuse me, the jury can take that and take all the other testimony and say, we don't believe her, we believe she was abused. This court cannot overturn that determination. And I believe I briefed that pretty well. This is a jury determination for jurisdiction. I think no matter what this court does, which I believe the court should deny the appeal completely, But whatever this court does, you can't, take away jurisdiction. And, last 2 points is.
Have you seen any cases where our court has ever vacated a finding of jurisdiction based on insufficiency?
I don't believe so. I didn't research that a lot, but I don't believe I did see one that you did. And if you did, I would have guessed it would have been a bench trial. I wouldn't think this court or the Supreme Court would vacate jurisdiction based on a jury trial because of that fact. Now, one of the other arguments, Mr. Sharon made was he didn't abuse her for 10 years. Well, that doesn't look at the mental abuse, and that's what the court found. You can't put the victim with the predator. And that's what she's asking this court to do. And the record was clear, and I argued it a lot, that from October 7th or October 24th to the date of the trial, she lost her whole support system. Mom testified, I told her early on, I'm not taking sides. In other words, your word isn't good enough for me, this happened, that your father did this to you. Her parents moved dad in with them. And mom and the grandparents had access to AS mom daily, grandparents multiple times a week. So her whole support system is supporting dad instead of her. Of course, she's questioning it when everybody else that she trusts or you should be able to trust, is saying, hey, we're supporting this guy, that you made allegations that abused you. And the last thing is ineffective assistance counsel. It's a 2-prong test. The second prong of the test is the results would have been different. There's no allegations in the brief that no matter what Mr. Kronzek did at trial, that these results would have been different for it to be an effective assistance counsel. I don't think there is anything else he could have done, especially being a part of this trial from the beginning. So I think the ineffective assistance completely fails because I don't think this court or reality says there would have been a different result no matter what Mr. Kronzek did that she's arguing. Thank you. And any questions?
No questions, thank you.
Thank you.
Counsel, you have time for a rebuttal?
A couple things have me confused. At page 18 of my brief, I referenced the counseling records along with Appendix A. I can see in my computer that I have an appendix that is marked confidential counseling records. I do believe I e-filed them with the court at the time that I filed my brief. So this reference that the counseling records don't exist or that it's missing pages, Appendix A is 107 pages, 106 if you take off the title page, Appendix A.
We understand. We can
Sure.
check the record.
Also, in terms of this argument that counsel, Ms. Moore, doesn't know if the CAC is inconsistent with the child's testimony because she doesn't have the CAC. It's not part of the trial court record. It wasn't played. I can't give that to the court. That would be improper under the court rules. I also can't file it with the court. That would be improper. It's always the prosecutor who generally files it because I am not allowed to disseminate it. But to really sit there and say that Ms. Moore doesn't know that the child's statement at trial was inconsistent with the CAC is at best intellectually dishonest. This child came up and began to testify. Why are you here? I'm here because my father molested me. When did that happen? It never happened. I said it happened, but it never happened. I can't tell you how many times she says on the record, it never happened. And so because she keeps saying it never happened, then the questioning turns to, well, you were interviewed at the CSC. Tell me what you said there. And then she says, oh, I said all of these allegations, but again, they didn't happen. It's clear from the record that what happened at the CAC, what she tells the interviewer at the CAC, is inconsistent with her multiple statements at trial that the abuse never happened. Finally,
Ask you this, I do think there are some complexities to the argument that you're making right there. I don't think the question was as, well, what did you say at the CAC, right? Because but that was not the question. It's okay. The transcript speaks for itself.
yes, Judge.
My question ultimately is, I mean, father's counsel had the opportunity, to cross-examine, right? There was,
The child.
correct,
Yes.
and elicited a lot of information to undermine what really, to basically make the points that father wanted to make, or father's counsel wanted to make
Yes.
regarding what happened, what didn't happen. That opportunity did happen. So that occurred.
Yes.
So this isn't a situation of hearsay where the person was never subject to cross-examination.
But it's not hearsay, it's impeachment. And the problem is, if it's impeachment, it can't be substantive evidence that these events happen. That's the problem, is that when the jury doesn't get the instruction, they don't understand that this evidence is admissible to judge the child's credibility, but not substantive evidence that these events actually happened. That's the whole point of 3.15, right? First of all, if something is for impeachment, it can't be hearsay, because hearsay is for the truth of the matter asserted. Thank you, Judge Cameron. So if it's just for impeachment, it can't be hearsay and it can't be substantive evidence. So you have a jury who is hearing this child repeat what she said at an interview how many months prior, and respectfully, Ms. Moore's statement that it's not hearsay because the declarant is in the courtroom. Hearsay is
On the stand. She said on the stand.
on the stand. Thank you. A hearsay out of court statement. The statements at the CAC are hearsay. They are used for impeachment. They are not substantive evidence. And the jury never has that explained to them. And I agree that the lawyer never made an objection. That's why it's raised in the alternative in ineffective assistance of counsel. I also just want to make one more. Everyone is throwing around waiver. There is a difference between waiver and forfeiture. Okay, waiver is the explicit approval. Ms. Sharon, do you agree that these jury instructions are correct?
Sounds
Yeah.
familiar.
All right, I've heard this before.
Yes, that's waiver. If I keep my mouth shut, that's forfeiture. Those are two different ideas. There is no waiver in this case. There may be forfeiture, and that's why there's ineffective assistance of counsel. I can tell that your honors are very tired from a very long morning. I will rest on my brief.
I mean, if you have additional points,
It's
you've got a
okay.
minute
I'm
or two.
clearly
minute
getting
or two
slightly
left.
excited.
Hey, if you're fired up, let's,
I did have one question in terms
Yes.
of the ineffective assistance of counsel argument.
Yes.
You heard earlier, are you aware, a guardian ad litem, are you aware of any case that's ever vacated from our court, vacated a finding of jurisdiction? I want to play that out a little bit more in a different direction. In the criminal context, if we were to find inefficiency, that's double jeopardy, right?
Oh, ineffective. Oh, inefficient. You said
Insufficiency.
inefficiency, and then I.
Inefficiency. Well, I was being
Do
inefficient.
you mean
I-
insufficiency?
Insufficiency.
Okay,
Yes,
that's
thank
what
you.
I
Yeah,
was-
yeah. Sorry, insufficiency of the
yes,
evidence in the
that-
criminal
correct.
context. If we were to find that, double jeopardy applies.
100%.
If I were to accept your argument of insufficiency in the context of a civil proceeding like this,
Yes.
you raised the argument, I'm playing it out.
Yeah.
What's the consequence? What's the consequence of you being successful on your insufficiency argument in a finding of jurisdiction in a termination proceeding?
I don't know that I can say the answer, because I think your honor is correct that I can't tell you how much time I spent researching case law. I'm not sure that I found anything, which I think is problematic. I think it seems that maybe these cases are a little too easy to affirm on appeal, but I agree with you. I haven't found one.
Okay, all right, just curious, because I don't even know, even if we would be that one case, what
But
do,
you should.
well, If I'm the trial court judge,
Yes.
what do I do with that? Can they petition again? Or are they precluded? So I don't think double jeopardy applies in a civil.
Of
proceeding.
course.
I'm wondering, I'm just trying to play this out. If I'm the trial judge,
Yeah, the statute allows you to amend the petition, right?
right, would they be able to do a do-over on an insufficient, if you're successful on insufficiency?
I don't know the answer to that, and I'm sorry. So you can always reverse on the ineffective and then you. I don't know the
All right.
answer, Your Honor.
All right, thank you.
Thank you, Your
Just
Honor.
curious.
Thank you. Thank you all for your time and your argument. It was all very well argued and some interesting and important issues for us to consider. That moves us to our final matter, and it's consolidated items. It's a consolidated case, item number 23. It is docket number 373347 in Ray NMO minor, as well as docket number 373350 in Ray PSO minor. We have a remote argument granted. Mr. Con-
Good afternoon, Your Honor. Your Honors. Guy Conti appearing on behalf of the appellant, and that would be Derek Ortwine.
Okay, you may proceed.
Thank you, Your Honor. So I basically don't have a ton to add to my brief. These are facts that, quite frankly, don't really make my client look all that good, and we understand that. But the problem is the Kaiser panel. Basically, you had a situation which was pretty similar in terms of the suspension or the termination, what the Jackson County Court called in the Kaiser case a termination, which was really a suspension because it was of parental rights. It was because the person needed, the parent could get reinstated on a psychological evaluation. So you have the same situation. My client's parental rights were suspended. During 23 out of the 24 months of the prescriptive period in this adoption petition, my client was subject to a PPO that was a pretty strict PPO as to the mother of the minor children. Your Honor, if essentially the only way that my client could have established regular visitation, regular contact with the children was through litigation or through an attorney, which he testified, and it was uncontested, that he did not have the financial ability to do.
Counsel, let me just pause you there.
Yes.
Couldn't he have contacted the friend of the court directly? Nothing prohibited him from contacting the friend of the court, noting his change of address, asking questions about the parenting time proceedings. He could have questioned the friend of the court directly. Isn't that true?
He could have, Your Honor, but the friend of the court, we're assuming that he knew he could have. There's nothing on the record there that says that he did know he could. And also the friend of the court, of course, is the friend of the court. They don't represent particular litigants. He had served some time for violating the PPO. He believed it was unjust. He was scared about being reincarcerated for contacting the family, even by mail, which would necessarily go through the mother, even if it was addressed to the children. So, Your Honor, but more importantly, and I know that you got, I was going to say you guys, but I'm not going to say it because I heard the argument earlier. This panel, I'm sure is very familiar with basically what we're saying, which is that, look, this is what Kaiser says, and it is the governing law, and the facts are very, very similar. It's hard to distinguish the facts, though there are distinguishments, I must admit, but it really comes down to two things. One, if this court believes that the central holding of Kaiser is not that if parental rights are terminated or suspended, in this case, and in the Kaiser case, practically as well, then we lose that point. Because if you believe that that's only a predicate or dicta, we're going to lose that point, and there's
Would you
no
have-
question about that.
Counsel, can you point to anything in the record that shows a good faith attempt during the look back period to contact the children?
I can't point to anything in the record that shows that, Your Honor. That does go to our citation of the unpublished case in Ray VRK, which basically says that the court cannot impose a wrongful conduct rule in this context. There is no wrongful conduct rule in the statute. It is not applied through, since there's a statute that governs, it is not applied through the common law. So
But you don't have anything that shows, look, he sent an email, he sent a text, he made phone calls to his attorney to ask about, hey, can I send some birthday cards to you and can you get them to my kids? Can you send them through the front of the court? Is there anything in the record that shows that?
there is nothing in the record that shows that, Your Honor.
Okay.
All right. And Your Honor, that is the first point, but there is an important second point, which is that much to my chagrin and opposing trial counsel's chagrin, the trial court lost the recordings of the record. And so trial counsel and opposing counsel and I had to reconstruct and get a stipulated order concerning the record, which we did. And it was entered by the trial court by stipulation of the parties. Your Honor, my recollection, even though it's not on the record, of the trial court's decision, and also the record that was stipulated to and ordered by the trial court, makes no finding at all that Mr. Ortwine was able to establish regular contact with the minor children.
I
Yes.
have a portion of the October 25th, 2024 order that was stipulated to, and it says, quote, it affirmed its original decision, and it says, quote, the other parent having the ability to visit, contact, or communicate with the child has regularly and substantially failed or neglected to do so for a period of 2 years or more before the filing of the petition. So it seemed to me that stipulated order did include a finding that the other parent had the ability to visit, contact, and that didn't happen.
You're saying, Your Honor, that the stipulated order referred to the earlier order?
It did, and those orders included a specific finding of that. It incorporated the prior orders.
All right, Your Honor. I would have to concede if that is the case. I certainly missed that, but I also I also wanted to point out that this case was decided on rehearing. But that being said, if that is the case, Your Honor, then I would have to concede that. And then we're left with the one point, which is, what is the central holding of In re Kaiser? Of course, this panel would be bound by that central holding. And our argument is that the central holding is that when there's a situation where a parent's rights have been terminated or suspended, when there is a PPO against them, or some sort of, in the Kaiser case, an accusation of sexual misconduct, so that the parent cannot effectively maintain regular communication, even if my client had gone to the front of the court. And mind you, Your Honor, there is no record that says he didn't. There is no record that says he did either. Although, you know what? I want to be honest with this panel. I don't think he did. And I'm not going to try and play games in terms of that. I do think that, though, it really is bad facts for my client, but good law. Um, and that's really what it comes down to. And I'm open to any questions, Your Honor.
Thank you. Any counsel, Judge, any questions for counsel? Okay, thank you, Mr. Conti. You have a few minutes for rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Jordan Ayler Smith on behalf of the petitioners appellees here. Working backwards, I would agree with you, Judge Bilhawk. The order does clearly make the finding regarding father's ability to visit, contact, or communicate with the children, and his decision just to not do that. I do think that that was included in the October order. It was also present in the July order very clearly. There was that issue of the clerical error where the checkbox was not checked, but the trial court did recognize that that was a clerical error. And I did cite an unpublished case from this court in my brief that says, that alone is not reversible error. Regarding brother counsel's argument on the Kaiser case, I went through this pretty extensively in my brief. I went through and I found eight cases, 1 published and 7 unpublished, that actually distinguished Kaiser on the fact of whether the parent had the ability to restore their visitation, just like father did in this case. And I take a little bit of issue with brother counsel's statement that there's nothing in the record that father knew he had this ability, because he's the one who filed in 2022 to get his parenting time reinstated, and then mother filed a counter motion to show cause because father was not complying with the child support order. That's what resulted in the friend of the court recommendation for no parenting time. But parenting time was not suspended. It was not terminated like it was in the Kaiser case. And also different from the Kaiser case, the parent in Kaiser still continued to make those efforts. The parent continued to make phone calls, continued to send birthday cards, continued to comply with, I believe it was some sort of like visitation counseling where the children were not involved, still complied with that and excelled at that. And that the Kaiser court based the finding that the parent did not have the ability to restore visitation on those facts. Those facts don't exist in this case. Father made no efforts during the 2-year look back period to make any sort of contact with the children.
What about Mr. Conti's concern about that efforts to do that would be in violation of the PPO?
So the original PPO did prevent father from contacting the children's school, but the PPO extensions, which were the only things that were in place during the look back period, did not prevent that. And father admitted that he knew that he could have contacted the school to get information and to establish contact with the children. Father also acknowledged that he had sent a copy of a letter from his doctor to mother's attorney, and that was not brought up as a PPO violation. He knew that he could contact mother's attorney without violating the PPO to try to establish some sort of contact because he had done it in the past. So I think that the problem here is that, first of all, father thought that the alleged allegations that, he violated the PPO were false. The allegations that he violated the PPO also were not based on any attempts to contact the children. They were based on his continued posting on Facebook and threatening mother and encouraging others to do so. So I think it's just fundamentally different here that father, had this knowledge that he could have contacted the attorney. He had the knowledge that the reason he was violated on the PPO had nothing to do with his contact with the children. And I mean, at the end of the day, it was up to the trial court to decide whether or not that fear was actually credible. And the trial court just did not believe that father's fear was credible in this case. And I don't think I forget exactly what the terminology that brother counsel used, but the bad acts rule applies in this case because it's just not, the facts are just so much different.
Any further questions, Judge Gamer, Judge Lindsay? Thank you.
Thank you, Your Honors.
Appreciate the well-briefed argument. Mr. Conti, any rebuttal?
Yes, Your Honor, briefly. It's easy to argue that my client should know he can do this, should know he can do that. The bottom line is the box that he found himself in, the PPO as well as the suspension of the parental rights, followed by when combined with the incarceration for what he believed was a wrongful finding that he violated the PPO. So the bottom line is in that particular case, he's either counsel's right. Opposing counsel's right. Either communicate with mother's attorney, and there's no evidence of the sophistication of my party, but your honors, he doesn't have to be sophisticated. He should not have to be sophisticated enough to be practically a paralegal to have to decide to figure out a way to get visitation with his children. He was terrified. That was in the record. He testified to it. It was not contradicted by any testimony or any evidence to the contrary, and there was no specific finding as to whether or not he was or not. So he has a situation. He's run out of money. He has no counsel at that time. He doesn't know what to do. He's scared of being incarcerated. Basically, at this point, he doesn't really know how he can do this. And it's not that, it's not that he doesn't want to see his children or have regular contact with them. One thing I also wanted to point out is that this is not the only way to terminate parental rights, your honors. If in fact our interpretation of Kaiser is correct, and if in fact parental rights should not be terminated because of adoption, there are other ways for parties in interest to proceed. So it's not so much, it's the two factors in the statute, and we believe that given his situation and given, yes, there is a difference between this and Kaiser in that instance, there's no question that the mother, who was the parent that was affected, made attempts to establish contact with her child. But the question on reading Kaiser is that just justification for the central holding? Or is that the dicta that the court used to reach the central holding of the law that that the Jackson County Court, in very similar legal circumstances, boxed that person into not being able to effectively establish regular contact and visitation with the kids? And keep in mind, the Kaiser case also pointed out that the mother did do isolated things like send Christmas cards and so forth, and that the Jackson County probate court had ruled that was not enough. And the court in that case said there's nothing wrong with that holding, that that these isolated attempts are not enough. So what we're asking this man to do is make a sustained attempt with no money, no legal counsel at that point, a PPO, and parental rights suspended. Thank you, Your Honor. Your Honors.
Thank you, counsel. That case will be submitted. And with that, that concludes our May Detroit case call for panel number 3. And these cases are all submitted, and we will be issuing decisions in the coming weeks or months.